All right, so we got quite a few topics that we're gonna talk about today. Some for clarification, some new information that you guys would be able to use, but this is more just about information. But there's quite a little bit of information that we're going to talk about here. At some point in time, I'd be happy to bring some of you up if you want to ask questions. You know, I can answer them the best that I can. But we're gonna wait just a little bit before we do that. So again, we have a lot of topics that we're gonna go through today. I have a list here of questions that have been coming up fairly consistently that I want to answer for you guys. Please share this so we can get as many people on. For those of you on TikTok, I know that you guys don't get to watch this in the future. So if you want to revisit this, if there's information or whatever that you want to watch this video once again, it is on my YouTube. We're streaming to YouTube right now. It's also on Facebook. Facebook, you only have it for 30 days. YouTube will have it indefinitely. So both Facebook as well as also TikTok, you guys can go to my YouTube page and you can find this live video and be able to get this information and recall it if there's something in here that you want to watch once again or share it. All right. So one big one. So happy Thanksgiving, everybody. Hope you guys had a good Thanksgiving with your family. We're back out on the road. What have we been doing? Well, again, I've been sick, you guys, with the embolism, the pneumonia, things like that. I'm getting a lot better now. The fluid is finally out of my lungs, and I'm actually able to breathe, better. It's been about 5 days that's been gone, but it's been a slow recovery after that. But nonetheless, so last week we did serve the state of Delaware. All right, it was the state of Delaware. It was their Senate and House because there was a justice subcommittee meeting that they had at the state legislature, the state capitol, and they allowed for public comments. The particular topic was on an initiative. It was a fact-finding initiative for a social justice program that they're doing. It's a joint funded program under the Biden administration. But basically the way that I got in was, we had to speak on the topic, right? We had to speak as it related to this social program to provide federal funding to help, underage communities underprivileged communities be able to grow and thrive. Well, what I said was that if the findings were going to be used to facilitate the abridgment of a constitutional obligation, then we need to inform you so that we can work together to fix the problem. Ultimately, that same argument is the same no matter, what we're doing. Like when we served the Georgia State Senate, it was the same way. Georgia State Senate, they had a meeting that was on the CAD system, their computer-aided dispatch system. And again, if that system is going to be used to facilitate the abridgment of a constitutional obligation, then they cannot proceed with approving such a system. So that computer-aided dispatch system, it would be dispatching law enforcement to, calls, right? And if those calls were for felonies and then they were going to arrest people without an indictment by a grand jury, then that system would be absolutely used to facilitate the abridgment of constitutional obligations. And that's how we were able to get in and actually speak on that. The state capitals are going to be very, very difficult, you guys, but that's the next step that we have to do. And so, we're looking for those opportunities. And it's a very short amount of time, but we need to get in there now, right? And the reason why is because the state Congress is the one that pays judges to do their job, right? And so if the judges are committing a crime or breaking the law or breaching their constitutional obligations, then they would be the ones that would be committing the emolument, right? The paying people to abridge their constitutional obligations, the crime that's committed there. And more importantly, when we talk about the specific Fifth Amendment provision, the grand jury provision, when you look at what it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. And my question is, well, who makes the decision to hold someone over? That's the judge. The judge makes the decision to hold someone over. The prosecuting attorney did bring the incorrect charge and instrument, but the crime or the breach of the constitutional obligation doesn't actually occur until the judge orders the person to be held over, which means that the judiciary is the one committing the crime. They're the one that's creating the actual base crime of deprivation of rights under color of law, but immediately they become co-conspirators with the prosecutor who did bring the incorrect charge and instrument. It's not the prosecutor that's committing the crime. It's the prosecutor that's relying upon an inferior state statute that permits them or directs them to abridge their constitutional obligations. But the crime of deprivation of rights under color of law does not occur until the judge orders someone to be held over for that capital or names crime. And so it's the moment that the judiciary takes action, and that's why we got to get into the state houses, because they're the ones that pay the judiciary. You know, for the city councils that we were serving, they're the ones that pay law enforcement. Yeah, law enforcement is absolutely engaged in this criminal conspiracy, you know, as detailed within the affidavits, as I've clearly laid out to all of you, as we laid out in our presentations during the public notices to the city councils. Yeah, absolutely. They're paying law enforcement to break the Constitution, right? They're engaged in a criminal conspiracy in doing so. For the county commissioners, they pay the sheriffs, and the sheriff is actually committing the crime when they go out and execute a warrant that's based upon a judge ordering someone to be held over for that capital or crime without the indictment of a grand jury. So, you know, we have to move in certain steps in order to make sure that we provide adequate notice to all of the opposing party, give them an opportunity to cure and thus correct their unlawful behavior. And if they don't, then that's on them, right? And so that's what we're doing. So last week we did serve the state of Delaware. We've already served the state of Georgia, and we also did the state of Pennsylvania. You guys don't have that video yet, but we did Pennsylvania, I believe the week before. And that was to the House. It was the state of Pennsylvania's House Judicial Oversight Committee. All right. But that's where we're at. So we are continuing to serve city councils, county commissioners, because that is, you know, a necessary step in continuing on with what we're doing. But we are absolutely moving into the state houses now to get them on notice served because they're paying the judges to commit the crime. The other thing is that when you consider where the person is being held, they're being held in a county jail. So when the Constitution says no person shall be held to answer, now the county commissioners are absolutely complicit in it because they're the ones that are actually holding them over. The order came from the judiciary, but the holding is done by the county. They are held to answer for that infamous crime without an indictment by a grand jury. Therefore, the county is complicit within it every bit as much as the judiciary is. And, you know, as a public official, right? As a public official, when you are informed that you are engaged in a criminal conspiracy, there's two things that you have to do. Two things you have to do in order to mitigate your culpability once being notified, right? And the notification doesn't have to come through a criminal proceeding or through a judicial proceeding. I don't have to give them a notice from a judge saying that they're breaking the law. All I have to do is inform them that they're breaking the law through a lawful service, such as what I'm doing. When I have an affidavit from an actual victim that has been charged by way of information from within a state, and that affidavit is delivered to the attorney general or one of the assistant attorney generals, that is a lawful notice. They have been notified of crimes that are being committed, and they have a lawful obligation to mitigate their culpability, or else they are actively engaging willfully and knowingly in that criminal behavior. So there's two things that you have to do. As a public official, two things you have to do to mitigate your culpability in a criminal conspiracy once you are informed, right? The first is you must inform the authorities of the crimes. You must report the crimes. That's why you have a lawful obligation to report. Public officials, right? When we come into your city council or your county commissioner meeting, or we come into your legislative committee meeting in the state legislature, if we come in and we inform you of a crime that's being committed, right, that you are paying for you are a part of that criminal conspiracy because you're paying for those crimes to be committed. You are now a part of it, and you have been lawfully notified of it. So the first thing you have to do is you have a lawful obligation to report, right? You must report that crime. Now, that doesn't mean that anything's going to happen, right? Because who you report it to has to actually investigate it and prosecute it and so on. But nonetheless, if you want to mitigate your culpability once informed that you're engaged in a criminal conspiracy, you have to report. And what's important to remember, public officials, right? Whoever this might be with the audience out here, once the proper agency to report to, because remember what the crimes are. These affidavits identify the crime of deprivation of rights under color of law, conspiracy to deprive of rights, kidnapping, and other crimes is ascertainable by the evidence on the record. The only law enforcement agency that has statutory jurisdiction to investigate deprivation of rights under color of law is the FBI. You must report to the FBI. And if you don't, then you haven't met the first requirement to mitigate your culpability in the criminal conspiracy once notified, right? You can stand back and you can say, oh, well, nothing's going to happen here or whatever. But if you don't take the lawful actions to mitigate your culpability as required by law, then you are an active participant in the criminal conspiracy. And that means that you are subject to all of the crimes that the entire conspiracy makes. You would be equally as responsible for the kidnapping of that individual or that child as much as the person that actually took the person or child, because that's how a criminal conspiracy works. So the first thing that you have to do is you must report the crimes. That's why you have a lawful obligation to report. Every single one of these public officials that we have provided notice to, every city council, every county commissioner, every state senator and legislator and representative, every single one of you, first off, has a lawful obligation, a duty to report those crimes to the FBI, to the proper agency. And if you didn't do it, you are actively a part of that criminal conspiracy, and you can be named as a defendant in the action, right? In the criminal action that ultimately is going to come from all this. Now, the second thing that you must do, right, public official, the second thing is you must notify your co-conspirators of your intent to no longer participate. All right. Again, you must notify your co-conspirators of your intent to no longer participate, but that must be done by an affirmative action, right? Meaning that we have to see that you did something. You must be able to show us that you actively did something to notify your co-conspirators that you are no longer going to participate. If you go behind the door and you say to Bob Senator, and you say to him, hey, we shouldn't do this anymore, that is not properly or doing what's necessary to mitigate your culpability. There must be an affirmative action that we can see. I must be able to see that you did something to notify your co-conspirators that you are no longer going to participate in the criminal conspiracy. And if you don't do that, then you have not mitigated your culpability once being notified and made aware of the criminal acts that's being committed, and you can be added as defendants in the action. Right? In the criminal action, you can be brought up on the criminal charges that the entire group is being brought up on. And remember, deprivation of rights under color of law is not a single crime. It's a crime every single time it occurs. So if I have 2.2 million affidavits, that's 2.2 million instances of deprivation of rights under color of law and conspiracy. That's 2.2 million felonies that, as prescribed by law, each one of them are punishable by death. This is a very, very serious situation that you guys have got yourself into here. And the more that you continue to ignore this and act like it's not happening and just gambling at the chance that maybe I won't be successful, maybe I won't be able to pull this off. I mean, you guys are putting yourselves at a lot of risk. I mean, a lot of risk. And there's going to come a point in time when this is going to be out of my hands, and you guys will probably be held accountable. And I don't think that the public's going to be very, very forgiving after being made aware, notified, and having a year to do the two things that you have to do. And that is simply preserve, protect, and defend the one thing that your institution was created to preserve, protect, and defend, the Constitution of the United States of America. So the Constitution, right? What it says in Clause 1 of Amendment 5, right, And you guys, no state can create its own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce that as though that is constitutional. Anytime that a state creates a law that is contrary to the Constitution, right, it results in an unconstitutional outcome. If you act unconstitutionally at the beginning, what you produce at the end is always going to be unconstitutional. The states do not have the authority to be able to act contrary to what the Constitution of the United States of America requires them to do, the limitations of power that the people delegated to them, right? Remember the 10th Amendment. People point at the 10th Amendment all the time and say the states have got the right to do this, but that's not true. The 10th Amendment doesn't say that the states have got the right to do whatever they want. The 10th Amendment says that the states have certain restrictions that are under the Constitution through the delegated power that the people gave. We restricted the states in certain exercise of power, and one of those exercises of power is if you are adjudicating a criminal case, then you must have an indictment by a grand jury before holding someone over for a capital or an infamous crime. Now we're staying with a representative, a state representative right now. We're spending the weekend with him and his family, and it's amazing because we're starting to see public officials that are asking questions, that are wanting to know more about this, that agree with this, and are asking, how do we fix this? And that's pretty amazing. It's awesome, right? And so, but we're spending the weekend here, and he actually brought up a point. He said now, the Constitution says a capital and an infamous crime, right? It identifies two different crimes. And he's like, well, I don't even know what those are, right? Well, first off, you're a legislator, right? You're a legislator. You're part of the legislative branch. This is not within your duties and responsibilities, right? So, yeah, I can understand why you wouldn't know what a capital or an infamous crime is. But I've noticed that a lot of you also don't know. Because we had someone that reached out to us earlier this week, all right, or I guess late last week, reached out to us and said, well, I went in and I challenged this whole grand jury thing, and the judge came back and said, well, it doesn't apply. Well, the reason why it didn't apply was because you were in a misdemeanor, right? You were being prosecuted for a misdemeanor, right? Not a felony, a misdemeanor. So let me come back and let me explain. The Constitution says that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, okay? So it identifies two different crimes there. One is an infamous crime and the other is a capital crime. Okay, a capital crime is pretty easy. That's a crime that's punishable by death, right? Pretty easy. Any crime punishable by death is a capital crime. Most states require an indictment by a grand jury for capital crimes. If you're going to prosecute for a capital crime, you gotta have that. And in fact, I believe that the guy up in Minnesota that unalived the Speaker of the House there, the state, I believe, charged him originally with an infamous crime, which I'll come back to that in a moment, an infamous crime. But then they said on the news just the other day that they're looking at making it a capital crime, but they have to get an indictment by a grand jury before they can do that. And that's a good example that most states do require an indictment by a grand jury to prosecute in a capital crime. But the same states do not require an indictment by a grand jury to prosecute an infamous crime, which is clearly unconstitutional, right? We already established that. But what is an infamous crime? An infamous crime, as defined by Title 18 U.S.C. subsection 4083. Now, I would recommend that you guys go to Black's Law Dictionary, volume 2007, right, and use it because that was the version that we used in 2019 in the original habeas corpus that we brought. But in 2019. 4083, what it said, and I understand that if you went out there and you looked at it today, it would say something a little bit different, right? Because they changed it to facilitate their argument, right? But what it said in 2019 was that an infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary, okay? More than 1 year imprisonment in a penitentiary. So if you can get a year and a day, if the offense that they arrested you for, you can get a year and a day, that is an infamous crime, right? Requiring the indictment by a grand jury, okay? Now, the United States Supreme Court came out in a case called United States versus Coachman, and they said it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. All right? And that's very, very important, because remember what the Constitution says. It says no person shall be held to answer. So the moment that you're held, the moment you're arrested, is what determines the infamous nature of the crime. So if you plead guilty and they give you 3 months, but you could have gotten 3 years, that is still an infamous crime, because it's the moment you are held, the moment you're arrested, that determines the infamous nature of the crime, that would thus, require or not require the indictment by a grand jury. But if you can get more than 1 year imprisonment in a penitentiary, then that is an infamous crime, right? Doesn't matter how much time, they sentence you to. If you could have gotten more than 1 year, that is an infamous crime. Now, a lot of people are also asking me, and I don't quite have an answer on this. I'm trying to work it through and trying to decide. But a lot of people have asked, well, yeah, but I got charged with 4 misdemeanors, right? And they're telling me that I can get 4 years from this single event. And again, I still don't have the answer for that. But what I'm leaning toward at the moment is that that's an infamous crime, because it was a single offense with multiple crimes in that single event, and that single event can result in, multiple 4 years of imprisonment, right? Even though each one individually can only get up to a year, because remember, non-infamous crimes, misdemeanors, you cannot get more than 1 year per misdemeanor. You can only get 365 days. So you can't get a year and a day. It must be, and that would mean that they are not infamous crimes. But I'm leaning toward, based upon everything I've researched so far, I'm leaning toward the fact that if they group a bunch of charges together, right? If they charge load or stack the charges based upon a single criminal act, I believe that that's going to be infamous in nature, because the single act, the single crime results in greater than 1 year imprisonment. But don't quote me on that quite yet. We'll get there, right? So, information versus indictment. Information, according to, and once again, if you were to go out to this particular statute now, it's going to say something different. But in 2019, right, the Title 18 USC subsection 555 said that information can only be used as the charging instrument for non-infamous crimes. Non-infamous crimes, misdemeanors. Information can only be used as the charging instrument for misdemeanors, right? That's what the law stated in 2019. I understand that today it says something different because they've changed it in order to facilitate their particular argument. But nonetheless, we're relying upon 2019 because the case was filed, initiated, and brought to Supreme Court of the United States in 2019. We are going to rely upon the law as it was at that point, because ex post facto, I don't give a shit what it says today. Title 18 USC subsection 555 said that information can only be used as a charging instrument in 2019. And as a result, I don't care if it says something different today. You can't change the law today to change the playing field for the 2019 case that we filed to the United States Supreme Court. We will rely upon what the law stated at that time. And it did not say what it says today. So, if information can only be used as the charging instrument for non-infamous crimes, misdemeanors, then why is it that the state of Oklahoma, for instance, 99% of people that are in prison in the state of Oklahoma are there on felony information, right? They were charged by way of information for a felony. That is an oxymoron. You can't be charged by way of information for a felony, because even to the federal law, it says that information can only be used as a charging instrument for non-infamous crimes, for misdemeanors, right? And yet they're using information for felonies. That is not constitutional. That is contrary to the Constitution, and it's contrary to the law. And we're not even getting into jurisdiction quite yet. We'll get into jurisdiction a little bit here. But, okay, so what is the difference between information and indictment? So information was created by the state of California, right? When they created their constitution, I believe in 1857, they created the concept of information. What information is the state, law enforcement officer, prosecuting attorney, whoever that might be, they receive information that you committed a crime. They take that information and they reduce it to writing in the form of an affidavit, a criminal affidavit, right? A criminal affidavit, criminal complaint, right? And then they take that affidavit, that criminal complaint, and they take it to a judge, right? A judge in the state. And they say to the judge, Judge, I'd like you to hold this person over based upon this affidavit of truth. That judge then looks through that affidavit and says, well, this looks good to me. Sounds like he committed a crime. There is sufficient probable cause to assume that a crime has been committed. Therefore, I'm going to issue a warrant ordering this person to be arrested and held over for this offense, right? Well, the problem there is that the judge and the prosecutor, the judge and law enforcement, they all work for the same entity, right? They all work for the state. And the state just so happens to be the accuser. Therefore, when you're charged by way of information, the state becomes your accuser, right? It's no longer a living person because the living person gave the information to law enforcement. They gave the information to a prosecuting attorney. And now the prosecuting attorney uses that information to prosecute you. And what happens here is that your right to confront your accuser, it evaporates because there is no accuser outside of information. And according to common law, an affidavit or information is considered truth because it's being presented to the court as though it's truth. The judge or the prosecutor or the law enforcement says this following information is truthful, factual, and correct as outlined and provided within this affidavit. Well, that officer doesn't know if the information is truthful, factual, and correct because they weren't a witness. But nonetheless, this is what the state of California created. So the state of California created in its inferior constitution, back when it established it, they said, well, you know, we don't like grand juries. We don't like indictments. We want to be able to prosecute much more easily. So what we're going to do is we're going to create something different, a different charging instrument. And that's exactly what they did. They created information. And they said that we're now going to prosecute for capital and infamous crimes based upon this information. So they brought it, it ended up going to the United States Supreme Court, right? That was eventually challenged by an individual that was known as Hurtado. And it was Hurtado versus California, state of California. And so he went to the Supreme Court of the United States on it, said to the Supreme Court, hey, I have the right to be able to, have an indictment by a grand jury before being held over for this offense. And the Supreme Court came out and said, no, you don't. That's not part of the due process protections of the Constitution. It's not required. And state of California's Constitution does something different. That's okay. State of California doesn't have to do what the federal Constitution says that they have to do, right? And obviously I'm paraphrasing there, but that's exactly what they did. The Supreme Court of the United States in 1884 or 1887 under the Hurtado case, they actually sided with the state constitution and said that the state constitution is superior to the Constitution of the United States of America. They removed and amended the limitations of power that the state of California had that was codified in the Constitution. When the Constitution says you got to have an indictment by a grand jury and the state said we're not going to do it, Supreme Court of the United States says that's okay. California, you can create your own alternative legislation, substitute it for the guarantees Constitution, and go out and enforce it as though it's constitutional because your law is now superior to the supreme law of the land. That's what the Supreme Court did. That's exactly what they chose to do in Hurtado. They did not support and defend the Constitution of the United States. They did not assert its supremacy and its power and its authority. And instead they said, California, you can do something different, which made the California state law superior to the Constitution of the United States of America. But so the difference between information and indictment is this. Information does not have a neutral, unbiased third-party decision maker in the process. The grand jury is there to provide a check on prosecutorial and judicial power, right? They're in place to make sure that before anyone is held to answer, before anyone is arrested, we got to make sure that someone is in the process that's going to review the accusations and make sure that we're not just arbitrarily or capriciously arresting people and holding them over in what's known as investigative detainment, which is exactly what we have today, right? Everybody's arrested and then they investigate. There's no evidence. They just have information, right? They just have an affidavit. And the judge said, oh, this all looks good to me. This is known as investigative detainment. And these became extremely popular right after September 11th. Prior to that, investigative detainments were absolutely unconstitutional under our system of government. They were always unconstitutional. You can never arrest someone and then investigate after the arrest because you are depriving a person of rights without due process of law. You're depriving them of the rights that the Constitution is designed to protect them against, and you're doing it without giving them without giving them proper due process. You have to investigate. You have to have evidence of a crime that's been committed. You have to present that evidence to a neutral, unbiased third-party decision maker. And if you don't, then we have a breakdown of due process that occurs, right? So the breakdown of due process is talked about pretty significantly by Blackstone. If you were to go into Blackstone and Blacks or whatever, and you were to look up what's known as an irrebuttable presumption of guilt, right? Irrebuttable presumption of guilt. What that is that you are presumed guilty based upon the mere fact of having been accused of committing a crime. You can never be presumed guilty based upon the mere fact of being accused of committing a crime. That is an irrebuttable presumption of guilt, right? You must be given the opportunity to be able to confront the hearsay accusations against you before your liberty is deprived. Thus, investigative attainments are unconstitutional. But nonetheless, so in the irrebuttable presumption of guilt, what happens there is that it requires the defendant to go out and collect evidence to prove that they're innocent. So we got an officer that's got information on you, right? And they take that information from this accuser. They've never validated it. They've never given you an opportunity to confront it, and they order your arrest. Now this judge comes and arrests you. You've never been given an opportunity. We don't know if that evidence is valid or that accusation is valid. It could be from a malicious, person. It could be in a high value divorce or child support, any number of other things. We can have malicious accusations come against someone, and now your liberty is deprived. Now you're taken to jail. Now you're put into a place where you've never, where your liberties are taken from you, your freedom and your right to go out and collect money and take care of your family and use your property, all these things that the Constitution is designed to protect you against. All of those are being taken from you without lawful authority because you've never been given an opportunity to confront those accusations against you. That's the role of the grand jury. That's the role of this particular check in the system. This is the only thing that was designed to protect the innocent, right, from suffering, right? This was what Benjamin Franklin and James Madison and Alexander Hamilton put in the Constitution to ensure that here in America, if our system of government works, innocents will not suffer. And yet the system itself has removed it, completely taken it away. 99% of all criminal cases don't have an indictment by a grand jury. Now, where do I get that number? Right? A lot of you would say that's pretty high. You're speaking out your ass. And I'm actually not. And the reason why is because yes, there are 13 states that do not conduct a grand jury at all. There's another 28 states that allow their prosecuting attorney to charge by information or indictment by their discretion, right? Both of those are unconstitutional, right? The ones that do not conduct a grand jury, such as the state of Washington, Article 1, Section 26 of its inferior constitution says, no grand jury shall be drawn or summoned in any county. No grand jury shall be drawn or summoned in any county. That particular provision is unconstitutional on its face, meaning that it can't function constitutionally because it removes the grand jury proceeding. That is facially unconstitutional, which means that every single person that the state of Washington has charged with a capital or an imp's crime, right, has got an unconstitutional void judgment because the law is directly contrary to Constitution. That's also the state of Pennsylvania. The state of Pennsylvania removed the grand jury from its Constitution, completely removed it back in the mid-'80s. So did the state of Connecticut. So did the state of Michigan. So did the state of North Dakota. These are states that have got facially unconstitutional provisions in their inferior constitution, which means that every single contract of guilt that's being created, whether it's a plea bargain, whether it's a jury trial, whether it's a bench trial, it doesn't matter. All of those derive from an arrest that was facially unconstitutional because the state's law is facially unconstitutional. Period. Right? We don't got to worry about the outcome. What we got to worry about is the law that the state relied upon to prosecute someone constitutional. And if it's not, then everything that the state did is unconstitutional. That's pretty easy, right? Now, the other states, the other 28, right? The other 28 that allow their prosecuting attorney to charge by information or indictment by their discretion, that is also unconstitutional, not under the facial unconstitutional element, but actually under the procedural element. Because you can never create a law that allows for you to use your discretion to break the law, right? obligations that the law creates, the constitutional obligations, those must be performed. So if the state creates a law that says, prosecuting attorney, you can charge by information by your discretion, that information is unconstitutional. Therefore, if you use your discretion to charge by information, you are using your discretion abusively to break the Constitution, right? And you can never abuse your discretionary authority with which you're invested in law to violate the law, right? Obligations created by law must be performed. You can never use your discretion abusively to break the law. Never. So the first issue is that the states cannot create a law that allows them to abuse their discretionary authority with which they're invested in law to break the Constitution. All right. And there's multiple places that I could reinforce that. I think that you can all understand. But according to Blackstone, any time that any public official abuses any discretionary authority with which they're invested in law, and this means any public official, judicial, executive, or legislative, if you abuse any discretionary authority with which you are invested in law, you commit 3 crimes. The first crime is perjury, because you made a promise, right, for a future outcome. You promised that you'd do what the Constitution of the United States of America says that you would do, right, and you didn't do it, and you've already implicitly invited punishment in the form of perjury should you fail to fulfill such a promise. So you are already guilty of the crime of perjury through the oath or affirmation that you took upon entering your office if you abuse any discretionary authority with which you're invested in law, right? In other words, if you don't do what the Constitution requires you to do, you've abused your discretionary authority, and now you're guilty of the crime of perjury. First crime. The second crime is extortion. Extortion is to bring about a result through illegal means, to compel a result through illegal means. So if you are abusing your discretion to bring about a result, right? If you're wanting someone to enter into a contract of guilt with you and you abuse your discretion to bring about that result, what you're doing is you're compelling a result through illegal means. You're illegally taking action in violation of the Constitution of the United States. You are acting unlawfully, right, in order to bring about a desired result. That is the crime of extortion. All right, so that's the second crime. The third crime is official oppression. And official oppression is when any public official applies the law unequally against like members of society, right? You can never apply the law unequally against like members of society, which brings us to the other issue. And that is that state of Washington, state of Oklahoma, state of Michigan, state of Pennsylvania, state of Connecticut, you cannot create a law that allows your public official to say, this person is going to get a constitutional right of indictment by a grand jury, but this person is not. That is a direct violation of the Equal Protection Clause of the 14th Amendment. State, you cannot do that, right? And it's not just a violation of the Equal Protection Clause of the 14th Amendment. It's also a violation of Article 4. Because Article 4 of the Constitution says the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. Which means that if there is a right that a person is entitled to in one state, other states cannot deprive you of that right, because that would be oppression. That would be violation of Article 4. So oppression is when a public official applies the law unequally against like members of society, right? So, okay. So the other thing is, so we talked about information versus indictment. The indictment, what it does is a grand jury, or the jury process in general, right, is a 2-part process. And if you guys want to learn a little bit more about the jury process, I would recommend going to a case called Duncan versus Louisiana, right, from 1968. That will tell you an awful lot about the jury process. Duncan versus Louisiana is when the Supreme Court of the United States incorporated the protection of the jury under the Sixth Amendment into restriction against the states by interference. Okay, but they talk a lot in that particular case about the 2-part process that makes up a jury. The first part of the process is a grand jury. The second part of the process is a petit jury. Okay, 2-part process. The first is the grand jury. What is the grand jury's role? Well, grand jury is 16 to 23 people, normal people. They're not controlled by the judiciary. They're not controlled by the prosecutor. They are an independent investigative body that is there for one purpose and one purpose only, and that is to provide a check on prosecutorial power to make sure that the state is not exceeding the power authority statutorily conferred upon them by the Constitution of the United States. They are independent, and they determine whether or not there is sufficient probable cause to assume that a crime has been committed. The people must determine whether or not a crime was committed, not the state. If the state is bringing an accusation against you through one of their agents, being a prosecuting attorney, CPS, a law enforcement officer, if the state is bringing an accusation against you, then the state cannot be presumed to be neutral and biased to act as a judge to determine whether or not there's sufficient probable cause to assume the crime has been committed. The same body of men that bring an accusation cannot be the same body of men that decide whether or not you're going to be held to answer for it if it's crime, or even prosecuted for it, or the outcome or sentenced or anything else if you're going to be profiting off of such sentencing. So the role of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury is to protect you, the accused, from a prosecuting attorney. That is the purpose of the grand jury. Which brings me to my point here, is that yes, there are facially unconstitutional states. There are states that are unconstitutional under equal protection, but 99% of all criminal cases, federal and state, do not permit the accused the right to be present to confront the hearsay accusation against them. So you're not allowed to be able to be present in that grand jury to confront the hearsay accusations that are against you because the prosecuting attorney has prevented you from being able to present your hearsay, your confrontation to the hearsay accusations, right? That is an abuse of process. Look up abuse of process, you guys. Abuse of process is when one side or one party gains an unnatural advantage over another. That's an abusive process. So when you abuse the process that you can get an advantage over another party, that is abusive process. And that's exactly what's happening. When a prosecuting attorney says, well, we're not going to allow the accused the right to be present, but I, the prosecuting attorney, am going to allow my client, the accuser, the right to present their accusations, but we're going to deny the opposing party the right to be present, that abuse of discretion or that abuse of process that has occurred, it actually results in a crime. And that crime is obstruction of justice. So if you weren't present in your grand jury to confront the hearsay accusations that were against you, I'll have to come back to that question there about whether or not they ask questions. Let me just get through this here. So if you weren't present in that grand jury to confront the hearsay accusation against you, it is because the prosecuting attorney obstructed justice by denying you your right to be present to benefit from the very proceeding that exists for your protection from the very individual that's denying you the right to the proceeding. If the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor, then when a prosecutor denies you the right to be present to benefit from that proceeding, that prosecutor has abused the process. The very purpose of that proceeding is to protect you from that person, and they're denying you the right to be present. Now, the crime of obstruction of justice, it actually is the enforcement element that drives out of the Title 42, the Civil Rights Act. And it's Title 42, USC subsection 1981. And what 1981 says is it says that all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. So again, every person within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. The Fifth Amendment is a law created by the United States. Therefore, it's protected by 1981. The grand jury is a proceeding created by the Fifth Amendment. Therefore, it's also protected by 1981. So when you are denied the benefit of the very proceeding that exists for your protection from the person denying you the right to be present, now you have a violation of 1981, which the enforcement comes under deprivation of rights under color of law and obstruction of justice. They are obstructing the administration of justice by denying you the right to be present. And what happens there now is that if you weren't present to confront the hearsay accusations against you, you were denied the right to benefit from the proceeding that exists for your protection in violation of 1981. The criminal statute is deprivation of rights under color of law. And now, if they had to commit a crime in order to secure an indictment, let me ask you, is that really an indictment? No, because if you commit a crime in the pursuance of an outcome, that outcome is unconstitutional. It's criminal. It's unlawful. So if a crime is committed in order to secure an indictment, that's not an indictment. That's an information signed by a prosecutor erroneously called an indictment because a crime was committed in order to obtain it, right? Which is why, which is why we're saying that if you were charged by way of information, right, whether you had an indictment or not, it's void. It's factually void. There is no indictment. The indictment doesn't exist because a crime was committed in order to do it. And that brings me to this point here is that you guys, you keep on asking me to come and help you with your case. And you guys keep on telling me about what's happened to you, right? That this judge was biased, or this prosecutor introduced false evidence, or this police officer was brutal, or, whatever it is, right? I get that things have happened to you that was unjust, right? But the question I have is was the arrest constitutional? Did they have the correct and proper charging instrument in place? And if they didn't, then everything that they've done is unconstitutional. Everything. That would mean that the arrest is unconstitutional because the arrest derives from a breach of a constitutional obligation. And if 99% of the people in prison and that have been charged with a crime or convicted of a crime across America, if 99% of them have got an arrest that was unconstitutional because either one, you didn't have an indictment by a grand jury, or two, you weren't present in the grand jury because they obstructed the administration of justice to deny you the benefit of the proceeding that exists for your protection, then that arrest is unconstitutional. Yes, I know that they've done all kinds of things after that was unjust, but none of that matters. What matters is the arrest. If the arrest is unconstitutional, every bit of that is void, on its face, ab initio. It doesn't exist because the arrest is unconstitutional. Therefore, everything deriving from the arrest must also be unconstitutional because it is all tainted by the illegality of the way in which it was obtained. You cannot have an unconstitutional arrest result in a constitutional outcome. Therefore, we don't got to worry about the judge's bias or the prosecutor's introduction of fraudulent evidence or the mishandling or denying of exculpatory evidence or the brutality of the police. We don't got to worry about any of that because all of that is void. Remember the timeline, you guys. The arrest is first. The arrest. Then you have the investigation, right? Because these are investigative detainments. Then you have the investigation. Then you have the adjudication. That might be a plea bargain. It might be a jury trial. It might be a bench trial. Whatever that is, you have that. Then you have a sentencing. Then you have a period of time that you are spent in prison or locked up. And then you get out and you have post-conviction release. And then you have fines that you got to pay. All of that is in order, right? Starting from the arrest. But if the arrest is unconstitutional, then that would mean that the plea bargain is unconstitutional because it happened after it. That would mean that the bench trial is unconstitutional because that happened after it. It would mean that the trial is unconstitutional because it happened after it. It would mean that the sentencing is unconstitutional. All of it is unconstitutional if the arrest at the very beginning was unconstitutional, and it was under this issue here, this absence of the indictment by a grand jury. These states that have got unconstitutional statutes in either facial violation or in procedural violation of the Constitution of the United States. This is a fact. So we don't got to worry about your plea bargain. All we got to worry about is your arrest. We don't got to worry about your bench trial. All we got to worry about is your arrest. We don't got to worry about the evidence that they suppressed. All we got to worry about is your arrest. We don't got to worry about the sentencing being too long or the fines being too high because of the arrest. The arrest is the beginning, and if we can show that they committed a crime at the very, very beginning, that they broke the law, that they act unlawfully, everything that they produce is unlawful, period, ab initio. Which is why I say to you guys, you have got to stop defending yourself. They want you to defend yourself. They're trying to get you to defend themselves, right? So they bring up these issues with you. They say, oh, well, look at what he did over here. Look at what he did over there. And when you respond to that by saying, I didn't do that, you're defending yourself. You're on defense. You are a defendant, right? And a defendant is where government wins, okay? So remember in sports, right? You have an offense and you have a defense. The offense is the strategically advantageous position because you're in a position where you're going to score, right? The other team is in a disadvantage because they're having to defend themselves. Anytime you're on offense in sports, you're going to win, right? That's strategically advantageous position to be in. So what I say to you guys is you need to go on offense. Stop allowing the government to be on offense because when they come to you and say, look at what you did, and you're like, I didn't do that. Well, bullshit, man. Go on offense. Accuse them of the crime that they committed against you because government can never commit a crime in the pursuance of an outcome. If government acts unlawfully at any point in the process, what they produce is unlawful, period, right? It's all for the poisonous tree. It's all ab initio, right? So if the arrest is unconstitutional for 99% of all convictions across America, as of this moment, we got easily 30 to 40 million people that could join together and say, wait a second now, my arrest was unconstitutional. My arrest was unconstitutional. I don't got to defend myself against all of this other process. I don't got to defend myself against the plea bargain, or I don't got to defend myself against the bench trial because none of that matters if the arrest was unconstitutional. And we can show the unconstitutionality of the arrest on a direct facial constitutional violations when the states decided they weren't going to do what the Constitution of the United States specifically restricts them in an enumerated obligation. So we can get a massive amount of people talking about one single issue. And this is what I've been trying to do with all of you. I'm trying to get all of you to talk about the one thing, my arrest. My arrest was unconstitutional. I don't need to defend myself anymore. I don't need to worry about what they're accusing me of because they're not on offense. I'm on offense. And if I go to the beginning, the very beginning, the start of the whole thing, and I say, what you did to me during the arrest is unconstitutional. You held me to answer for this offense without an indictment by a grand jury by the breaking of the law, by the unlawful act of the government at the beginning. Everything they produce is unlawful. So we don't got to worry about that. And now we can get a massive amount of attention onto one single issue, which is what we actually have to do. We have to do that, okay? We have to. This is the only way that we're going to get this case to be heard. The Supreme Court knows about this. They've known about this for years, right? They don't want to hear it. They're ignoring it, right? But the only way we get over their ignorance is we bring attention to the issue. We magnify that issue. And as we magnify it and we get millions of people talking about one issue, all of the other stuff, all the noise is reduced, right? Right now today, we got a lot of people who are talking about, well, yeah, but I had a bench trial. Yes, that bench trial was unconstitutional. That's not a jury. That was a judge. It was a state of party and the state adjudicated. And, yes, we get that. We get that you were compelled to act as a witness against yourself when you were entered into a plea bargain because of the threats, intimidation, coercion, or duress that the prosecutor brought against you. We get that, right? We get that. We know that the judge suppressed evidence and, we know these things, right? We know that you had an excessive fine that was brought against you. But as we talk about each one of those things, what it does is it draws people into little pockets, right? So you got a million people over here talking about judicial misconduct. You got a million people over here talking about prosecutorial misconduct. You got a million people over here talking about excessive fines. And you got a million people over here talking about evidence suppression. You got them spread out amongst a whole bunch of different issues. But the root issue for all of them is my arrest constitutional? And if it's not, then we can take all of these different pockets of people that are talking about their own individual issues, that are defending themselves, and we go on offense. And we can talk about the crime that's being committed cumulatively against all 40 million of the people. And now we magnify an issue by bringing down the noise of the other issues. Right? When we stop talking about the issues that we are defending and we go on offense and talk about the crimes that they're committing, now we magnify the issue, and now the Supreme Court of the United States cannot ignore it any longer because we've zeroed in and magnified the specific issue that they must address. And that is, you committed a crime at the very beginning, and as a result of that crime, what you produced after that crime is all unlawful. By your unlawful acts, government, what you produce is unlawful. And that's because there's a maxim of law that says that any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. So if the act at the beginning is unlawful everything after it is also unlawful. It can never become lawful. If you break the Constitution at the beginning, then at the end, it still is a broken Constitution, right? It still is unconstitutional, and nothing that they can do. No time can make it constitutional. No subsequent legislation can make it constitutional. Nothing can make an unconstitutional act at the beginning constitutional. And that's the point here, right? The Constitution says it. State didn't do it. Therefore, what the state produced is unconstitutional. There is no statute of limitations on a constitutional violation. Just because you went and served your time doesn't make the judgment valid, constitutional. No, it still is unconstitutional, right? Just because, they found you guilty by a trial, right, or a jury of one's peers doesn't make the judgment valid. No, because the beginning was unconstitutional. If the act at the beginning is unconstitutional, then everything derives from it must also be unconstitutional. There can never be subsequent legislation or time that makes it constitutional. Any act at the beginning must be constitutional at the end, or unconstitutional at the end, if it's unconstitutional at the beginning. Okay, so so there's a couple things that's going on that's really interesting right now in the news. Really interesting. And I want to point out two of them, right? Because I want you guys to be thinking about what you're hearing in the news, right? And thinking about how God is actually building this for us. I want you guys to get excited because we have a lot to be excited about right now. We have a lot to be excited about, right? Now, one is you guys are hearing a lot of talk. And again, this isn't about politics. This is not about Democrat or Republican. I care about the rights of the people. I don't care about party. I'm not here to boast one party or another. But what I am seeing is certain things that are happening that's in our absolute benefit. And one is, you guys all hear people talking about these legislators and public officials that came out and said, you don't have to obey unlawful orders, right? You guys heard that? You don't have to obey unlawful orders. And now it's all over the news. Like now Trump is, talking about bringing Kelly back and recalling him back to active service so that they can prosecute him in a military tribunal. Nonetheless, none of that's what I'm talking about. What I'm talking about is the message, right? The message is that you do not have to obey unlawful orders. That's the message, right? And that's a very important message, especially as we watch it play out right now. Because this message is going to go to the Supreme Court of the United States, right? This whole video and this whole conflict, everything that they're talking about is huge for us. Because let me ask you, right? Think about this indictment by a grand jury issue. The law requires an indictment by a grand jury because the Constitution says so. The reason why they're not doing it is because the Supreme Court of the United States in 1887 came out with a ruling that said you don't have to do what the Constitution says you have to do. That was an order. That was a ruling that they put out that is unlawful. And these attorneys and prosecutors and judges are obeying unlawful orders right now because the order from the Supreme Court is unlawful. It's contrary to the Constitution. So all of these attorneys, all these prosecutors, all these judges are all obeying unlawful orders. And as we watch this play out, you guys know that you can't obey unlawful orders. This is basic civics 101. That if I tell you to go out and steal from someone and you say, well, I was ordered to do it, so I did it, that doesn't absolve you of your criminal conduct. No, ignorance of the law is no justification for having broken the law. So if you're told that you don't have to obey the law, if you're told, well, you don't have to have an indictment, but the law says you do, then guess what? You cannot, you must disobey unlawful orders. So that's pretty interesting. It's pretty interesting to see that actually playing out right in front of us as we go into this and we start, moving to these final stages of this litigation. But that's really interesting because that's exactly what's happening. That's what we're arguing is does the Supreme Court of the United States have the constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution? The answer is no. They don't have the authority to order anyone, judges or prosecutors, order them that you don't have to follow the law, the Constitution. And yet that's exactly what's happening. Every day, judges rely upon a judge-made ruling in order to violate the Constitution, to commit an unlawful act. Now, the other thing that's really interesting is this whole tariff discussion, right? And remember, 2 weeks ago, the oral arguments were presented to the United States Supreme Court on Trump's tariffs. Now, absent, once again, this is not political. We're not talking about Trump's decision to do it. What we're doing is we're looking at how this actually illustrates and coincides with what we're doing here. All right. So the whole issue, the basis of the issue was presented to the United States Supreme Court was, does the executive branch have the lawful authority to create a debt or a tax against the people? Right. If you listen to the oral arguments, that's basically what the whole thing was about. Right. So let's look at what's going on. So Trump and the administration said, well, we're going to implement tariffs, right? And those tariffs are going to generate revenue, right? They're going to create revenue for the Treasury, which is what he said numerous times. Well, we made trillions of dollars off of these tariffs. So that is revenue generating, right? And so the whole issue that went to the United States Supreme Court was, does the Supreme Court of the United States, or does the executive branch have the authority to tax the people? And the answer is no, right? Because all tax must originate from the legislative branch. And that was the questions that the justices were asking, both parties was, they were trying to determine whether or not this was a revenue generating or whether this was regulatory, right? Whether it was for other purposes. And ultimately, I think that the Supreme Court has determined that this was revenue generating. But ultimately, the decision that the Supreme Court's going to come out with, and I think that if you guys listen to the oral arguments, right, you listen to it and you listen to questions that were coming from the justices, I don't think that any of the justices were actually on the government side on that one. Like, they were very, very skeptical of these tariffs and the fact that they were creating revenue for the Treasury, right, which would be a tax against the people because the people actually paid for that and thus and so on. But if the decision comes out that says, against the administration, against these tariffs, that's well in our favor, because that's my issue. That's what I'm talking about, right? Because think about individually, right? When you are charged with a crime, the word charge is very important, right? Charge is an accounting term. So the way that our system works, right? The way it works is, if you choose to violate the law, you incur a debt that is owed to society, to which you are charged, called to account, so you can pay the debt. So you have a debt against you, right? And that debt must be paid, but the debt is against society. So my point here is, and work with me here, understand here, is that this is an economic system. If you have a debt that is owed to society, then that is a tax that is brought against you as an individual. That's what breaking the law is. Now, the reason why I bring this up is because in a courtroom, all three branches are represented. The first branch is the judicial, right? Judge. The judge represents the judicial branch. The prosecutor represents the executive branch. The jury represents the legislative branch. The jury is the legislative representative. So the problem here is that if the debt or the tax against the people does not come from a grand jury, then that is a debt or a tax that is against the person that's created by a branch of government that does not have the constituted authority to create the debt or tax against the people, right? So if the executive branch in Trump's tariff case, if the executive branch does not have the constituted authority to create a tax against the people, which is the decision that we are praying will come from the Supreme Court here, then that will absolutely coincide with what we're doing here. Because if the charge originates from a prosecutor through information and not from the jury, right? If the people and the legislative branch does not determine that you owe a debt against the people, then that means that the executive branch has created the tax against the people, and that is a branch of government that does not have the authority to create tax against people according to the Constitution. So what we're looking at here is the tariff case from the Supreme Court. If they come out and say, executive branch, you don't have the authority to create a tax against the people, which is the outcome that I'm certain we're going to get, then that will also apply to what we're doing here. Because if a prosecutor creates information, that means that the prosecutor who represents the executive branch is creating a debt or a tax against you individually, and it's not coming from the proper branch of government that has the authority to be able to create the debt and tax against people. So, we're seeing these two things play out. It's very exciting. There's other things, but those two things I wanted you guys to be aware of and just think about there. All right, so the other day I had someone post some stupid bullshit about how I never talk about how the states have the right to govern within their limits, and that I never use the Federalist Papers, or that I need to read the Federalist Papers so that I can better understand the Constitution. And that was the most idiotic thing that I've ever heard someone say to me, because if you are saying that the states have the right to be able to govern within their jurisdiction, right, and then you go and you use the Federalist Papers to be able to back up your statist argument, what you got to understand here is that when our country went from a confederacy into a union, we had two different groups of people. It was called the statists and the federalists. Statists and the federalists. The statists believed that the states, that the state had the ultimate authority, that they had the power, right? This was the confederacy, because the confederacy was sovereign states, right, that had the sovereignty to be able to govern within their jurisdiction however they see fit. They're not subject to the central government's laws, and they can govern their people however they see fit. That was the statist view, right? And it put emphasis on the state governments and the state laws. But the Federalists, right, which were the people that wrote the Federalist Papers, they believed in a strong central government, right? That we have federal laws, the Constitution, and that Constitution governs all the states. And the states gave up their right to be subject to the federal Constitution. Therefore, the states cannot exceed the power of the Constitution of the United States of America. That was the Federalist view, right? So the people that wrote the Federalist Papers were Federalists. They were against the statist view. James Madison, what he created with three separate but equal branches of government, was battling against the statist perspective by providing Federalist view, which means that the federal government's laws were more powerful than the state laws. Therefore, the states were not able to govern however they see fit. They must operate within the limitations of delegated power that the people gave to them through the Constitution of the United States of America. So whoever says to me that I need to read the Federalist Papers in order to better understand how states have got the right to govern within their jurisdiction, you have no clue what you're talking about, and you've lost all credibility with me whatsoever, because you don't even realize that you are a statist that is trying to use Federalist rules or Federalist writings to justify your statist perspective. Those are two completely different things. James Madison and Alexander Hamilton did not propose that the states have the authority to be able to govern however they see fit within their jurisdiction, because that was a statist view, was not a Federalist view. And the Federalist view was ultimately what overcame and was brought into place through the Union, through the ratification of the Constitution of the United States of America. States are limited in their powers, which means that they're not sovereign. They're actually non-sovereign, which brings me to statist view. Okay, so immunity, sovereign immunity. That's what it was, sovereign immunity. So I was supposed to go on to Wisdom last week with Cameron. And guys, I haven't been feeling good. Cameron, if you're on here, I'm so sorry that I didn't make it that day. I have not bounced back completely yet. I'm feeling a lot better, but Cameron with Wisdom, he wanted me to come on and talk about sovereign immunity, and I didn't get to do it. So I wanted to come on here and talk about sovereign immunity. All right, so this is history. right, guys? This is history, and you'll probably have to listen to this a couple different times to be able to understand, everything I'm saying here. But if you want to combat sovereign immunity, this is how you do it, all right? And remember, if you want to go back and you want to watch this again, you want to take notes, maybe I'm speaking too fast for you, you can go over to my YouTube channel. This is streaming live to YouTube. It will be available later on tonight through there, and you'll be able to do it. But let me give you the history of sovereign immunity, right? So sovereign immunity is based upon the doctrine that the king can do no wrong. The king can do no wrong. It's English. It's British doctrine, right? Because in Britain or England, the king, right? They have a monarchy, and the king makes the laws, right? That's how their system is set up. The king makes the laws. So the king can do no wrong because he can't break the law because he can change it. So in order to be able to arrest a king or sue a king, you must get his consent. He must consent to you. He must give you permission. He must agree that he broke the law. But the king can do no wrong, right? And so in England, what happened was that the king, you cannot arrest him because he makes laws. Laws come from him. Unless he agrees that he broke the law, then he can't break them because he would just change them, right? This is the concept of sovereign immunity. The king can do no wrong. What the king did then was he granted immunity onto all of his agents. The judges and his prosecutors and law enforcement, he granted immunity onto them, his immunity onto them, because he said, here in England, judges make the law. He delegated his authority for judges to speak the law. So in England, what a judge says is the law because the king, the monarchy, delegated his authority for his agents to speak the law. So you can't arrest a judge in England because he is immune. The king granted him his sovereign immunity. The king can do no wrong, and the king delegated his immunity to his agents. That is the whole concept of sovereign immunity. That's where it all derives from, is from this doctrine from England. Problem is that here in America, we don't have a king, right? Even as Thomas Paine said, in a free society, the law is the king. So our king is the Constitution of the United States of America, the law, right? And so the people the judges here in America, they don't speak the law, right? We didn't delegate that authority for them to be able to do that because we don't have the monarch. We didn't do that. That's why Clause 1, Article 1 of the Constitution says all legislative power is vested in Congress of the United States, because we did not delegate the authority for the judicial branch or the executive branch to create law. The only branch of government that can create the law is the representative branch of the legislature, the representatives of the people. Now, absent all that, so what happens now is the origin of sovereign immunity is a British doctrine that the king can do no wrong. You can't sue a king, you can't arrest a king because he is immune. Okay, so here in America, right? The very first case that the United States Supreme Court ever heard was a case called Chisholm versus Georgia. Chisholm versus Georgia. And it was 1793. And in the case of Chisholm versus Georgia, what was happening was that Chisholm lived in South Carolina, and he was suing Georgia for failure to pay bonds, right? And so he sued, and he ultimately won. It was a 4-1 decision from the United States Supreme Court. And what the Supreme Court said was that the states, right, that they gave up their immunity in order to subject themselves to the supremacy of the Constitution of the United States of America. They gave up their sovereignty when they joined the Union and subjected themselves to the supremacy of the Constitution. So now you have the ability for Chisholm, a person, to be able to sue the states, and the states are not sovereign because the definition of a sovereign state is a state that is complete in itself, not subject to a higher government's laws, right? So the definition of a sovereign state is a state complete in itself, not subject to a higher government's laws. So if a state is subject to a higher government's laws, it is not sovereign, because the definition of a non-sovereign state is a state not complete in itself, subject to a higher government's laws. So what the Supreme Court said in 1793 is that the states are not sovereign because they gave up their sovereignty when they joined the Union and subjected themselves to the Constitution of the United States, the higher government's laws. The state of Georgia is not sovereign because it's subject to a higher government's laws. That means that it is non-sovereign, and as a result, it can be sued, right? Because it's not the sovereign. It's subject to the higher government's laws, the higher Constitution. So Georgia lost. Chisholm won, right? But then what happened was immediately after that, the state started throwing a fit, right? They're like, well, wait a second now. Had we known that we were giving up our sovereignty, and that we could be sued or held accountable for the things that we do wrong, that the king can do no wrong, the government can do no wrong. Had we known that, we would have never joined the Union. We would have never subjected ourselves to the supremacy of the Constitution. We would have never done it. It was going back to the statist view where the states were saying, oh, well, the state laws are more powerful. States have got the authority to do whatever they want, and we're not subject to the Constitution of the United States, and because we want to be able to proceed with immunity, right, under the British doctrine. So 1793, Supreme Court says states are not sovereign. They can be sued or sue, right? And as a result, states then threw a fit. And then in 1795, we passed the 11th Amendment. 11th Amendment. Now, the thing about the 11th Amendment is that a lot of people point to it and say, well, the 11th Amendment, is what established the immunity. And that's not actually true. What happened with the 11th Amendment was that it technically overruled the Chisholm decision, right? The Chisholm ruling from the Supreme Court. What the 11th Amendment says is it says that a citizen in one state cannot sue a different state. So a citizen in one state can't sue a different state. It resolved the Chisholm versus Georgia issue where the Chisholm lived in South Carolina and he was suing a different state. So the 11th Amendment, it bars and technically forecloses upon the ability for a citizen in one state to sue a different state. That's why I can't sue the state of Texas. I could sue the state of Washington, which is what we did. We started the case against the state of Washington because I can sue my own state, right? But I can't go to Texas and sue. And if Texas is doing the same thing that the state of Washington was doing, then I wanted to make sure that Texas was held accountable, which is why I've gone and I've collected all these affidavits from all of you, right? That's why I've taken your affidavits and I've served your Attorney General and your Supreme Court justices with these notices with the affidavit, because I can't sue Texas, but Gary can, and he's my affiant from the state of Texas. So he can, because he is a citizen of the state of Texas, he can sue the state because the 11th Amendment does not technically foreclose upon that, right? But I can't do it, but he can. But I want to make sure that when we beat the state of Washington, that Texas is held accountable and that Oklahoma is held accountable and that, Connecticut and Pennsylvania and Michigan and all these other states are held accountable, but I can't sue them because I'm a citizen of a different state. I have to work within the parameters of the existing Constitution, and that Constitution in 1795 said that a citizen of one state cannot sue a different state. Now, that's 1795. 11th Amendment was enacted. Then what happens is we have 100 years of huge Supreme Court cases. McCulloch versus Maryland, Cohen versus Virginia, Martin versus Hunter's Lessee. These are huge Supreme Court cases that is made by the United States Supreme Court. And if you go and read those, you go and read McCulloch versus Maryland, Cohen versus Virginia, what it says is it says that the state is not immune, it can be sued. McCulloch lived in the state of Maryland. Cohen lived in the state of Virginia. So he could sue his state, and the Supreme Court said the state is not immune. The 11th Amendment does not make the state immune. It only says that if McCulloch lived in Texas, he couldn't sue Maryland, but he didn't. He lived in Maryland, so he could sue. So when you look at the cases from 1795 all the way until 1890, what you find is that the Supreme Court consistently said that there is no sovereign immunity and the states can be sued by individuals that live within their states. Now, fast forward to 1890. 1890, a case came up that it was called Hans versus Louisiana. Went to the United States Supreme Court. Hans versus Louisiana. And Hans lived within the state of Louisiana, and he was suing his state, I believe also for bonds as well, but nonetheless, so he was suing his state. The Supreme Court of the United States came out, and what they said, and I'm paraphrasing here, but you're welcome to go out and read it. What they said was, we don't read the 11th Amendment literally. We read the 11th Amendment figuratively, and we believe that its intended purpose was that the states were immune and sovereign. Thus, sovereign immunity was born in 1890. Prior to 1890, you could sue a state, and they were not immune because the Constitution doesn't allow for immunity to exist, right? States can sue or be sued. But it was born in 1890 by judicial ruling. And even the Supreme Court said in that ruling, we don't read it literally, right? We're not reading the 11th Amendment literally. We are interpreting it. We're saying that, it was intended to make the states immune. If the Constitution doesn't make the states immune, the Supreme Court can't amend the Constitution through a judicial ruling, because that is a branch of government that does not have the lawful authority, the constitutional authority to be able to create law, and thus they created law. They created an amendment to the Constitution in an other than lawful manner, right? So the Hans versus Louisiana case was a judicial ruling that created an amendment to the Constitution. It exceeded the limitations of power that the people delegated. We did delegate to the central government, or we did delegate the limitation of power that a person in one state can't sue a different state. But we did not delegate the power that a citizen in one state cannot sue their own state. It was created by the Supreme Court through judicial fiat, through an amendment in an other than lawful manner. Now, what's important is that was the moment that sovereign immunity was born. Prior to 1890, sovereign immunity didn't exist because the states gave up their sovereignty to join the Union and subject themselves to the supremacy of the Constitution of the United States of America. But all of a sudden, the Supreme Court came out 1890 and said, yep, sovereign states are sovereign, right? They are the king now, right? You can't sue them without their consent. That's why you got to get the consent of the state to sue them, right? So it was created in 1890 by an other than lawful manner. Now, what's important is you can also go to a case from 1996 at the United States Supreme Court, and it's called Seminole Tribe of Florida versus Florida. Okay, so Seminole Tribe of Florida versus Florida. And it wasn't that they overruled the sovereign immunity issue. They didn't change it, right? It still exists. But what's telling is the dissenting opinion that was written by Justice Souter, right? So what Justice Souter said in 1996 was, he said, there appears to be two versions of the 11th Amendment that exists. One created by the people in 1795, the other conceived by this court almost a century later, right? So again, there appears to be two versions of the 11th Amendment. One created by the people, the other conceived by this court almost a century later. So what Justice Souter was getting at there was that he's reading the 11th Amendment that the people enacted in 1795. He's reading it. But he's being told that there's another one, right, that was created in 1890, but it's not created by the people. There appears to be two versions of the 11th Amendment. One that the people created in 1795, and the other conceived by the court almost a century later. The whole point here is that, does the judicial branch have the constituted authority to conceive law? Can the legislative branch legislate? Can they create law? The answer is no. They can't, because all legislative power is vested in Congress of the United States. So what Justice Souter was saying there was, there appears to be two versions of the 11th Amendment. One that is lawful, and the other was created by the Supreme Court of the United States. Which one is valid, right? There appears to be two versions. The thing is that the one created by the court, the one conceived by the Supreme Court, is not valid because it's contrary to law, making it unlawful. If the Supreme Court of the United States wants to have sovereign immunity, great. Present it to the people with the issue and get the people to adopt it and ratify it into the Constitution, into the law, in accordance with the special amending procedure of Article 5, the procedures necessary to make law. Otherwise, it is a branch of government that's legislating without the constituted authority to legislate. It is an amendment to the Constitution that's being done without following the proper constitutional procedures codified in Article 3 and Article 5 for the amendment to the Constitution of the United States, the special amending procedure. So sovereign immunity is a concept born out of judicial ruling that has no grounding whatsoever within the Constitution of the United States of America. We have all kinds of supporting evidence and law for that. Constitution does not bar a person from suing his own state. The 11th Amendment does not do that, not in any way, shape, or form. You guys are welcome to go out and learn that yourself, right? But the 11th Amendment does not bar a person from suing their own state. The Supreme Court created that through a judicial ruling, and in doing so, they amended the 11th Amendment. They added to it, they conceived law, right, without having the constitutional authority to be able to conceive law, right? So we're living under a world where we believe that the state is sovereign, but that's not grounded in law. That's grounded in judicial ruling, which means that they are breaking the law by order of the Supreme Court, not by order of the people, right? And if you violate the law of the people, well, you are acting unlawfully, because only the people can create the law. So again, sovereign immunity is a creation of the court. It's not a creation of law. The law never enforced that. Now, there's another thing that that when you look at the not the antitrust laws, but the I just drew a blank. Never mind. We'll move on from there. Okay, so that is immunity, and that's the history behind the immunity. So the state cannot have immunity because the Constitution didn't delegate such a power. Now, another thing that you guys should be thinking about is that the state can't assume powers that the people don't have, right? We don't have immunity, right? Because we could be prosecuted, therefore we can't delegate immunity. The government can't have powers that the people themselves inherently don't have. So we can be prosecuted. We can't delegate immunity from prosecution because that would be a power that's not inherent to the people, right? So you guys need to really be thinking about that as well, right? That we, the people, cannot delegate a power that we ourselves don't have. And if we don't have immunity and we delegate our ability to be able to be held accountable for the crimes that we commit, and we authorize the government the power to be able to prosecute, then we can't give them immunity. We can't delegate that power because that's not a power inherent to the people, all right? The other thing is this, right? And this goes back to word etymology. So for those of you who like origin of words, this is the origin or this is where immunity comes from. So in England, once again, the king can do no wrong. You cannot arrest a king for a crime because he is sovereign, okay? Now, the way that you prosecute a person, this goes back to the indictment issue. An indictment is known as a bill. It's a bill of indictment, right? So if you choose to violate the law, you incur a debt to which you are brought to account, to which you're charged, then called to account, so you can pay that debt. All right. But the way that a criminal action is initiated is through a bill, right? That's why when I go back to the whole tariff thing, if the grand jury doesn't create the debt or the tax against you, then it's from a branch of government that did not have the authority to create the tax. But if the bill of indictment is what is used to initiate a criminal proceeding, right? The reason why a king cannot be held liable is because in England, a king is known as nobility. Nobility. He is noble, right? And that's the etymology. That's the origin of that word. Nobility means you can't bring a bill against them because they're noble. And that's why here in America, we wrote into the Constitution, Article 1, Section 9, Article 1, Section 10, that there shall not be patents of nobility in the federal realm And then Article 1, Section 10 says no state shall create patents of nobility because every single person is billable for the crimes that they commit against the people of the United States. Everyone is billable. There is nobility like we had in England. But that is the etymology of the word. That's where that word originates from, is nobility. You can't bill a king for a crime because he is immune and sovereign, because he's nobility. Here in America, you can't have nobility because you are all fully billable for your crime. So bill, nobility, the origin of that word derives from the concept of sovereign immunity, right? Where you can't bill a king for a crime because he is no bill and nobility. Okay, so we talked about going on offense. All right, I want to talk about the hierarchy of law real quick. Hierarchy of law. So, so law has a hierarchy, you guys, right? It's a certain structure, right? And the way it's supposed to work is that the Constitution of the United States of America is the foundation. It's where it starts. Everything starts from that. It was the body of law that originates from the very beginning, and everything must comply with it. It's a very small body of law. It's only 4 pages. It's a very small body of law, but it's the foundation. So when you consider the foundation, somewhere down around in here, right? I think all 3 video can see it. It's the foundation, very small body of law. Then next is known as treaties, right? Treaties. So that is law that's created, but it still must be consistent with the Constitution. A treaty that's unconstitutional would be unconstitutional. It's inconsistent with the Constitution. So the next body of law is treaties, and it's a little bit bigger, right? I don't know how many thousands of pages it would be, but each treaty would be, 100 pages, and so it's a body of law. It's a little bit bigger, but that's the next. So first is the Constitution, then is treaties, bigger body of law. Then you get into what's called statutes, right? Statutes. And statutes, sticking with the federal side, would be, the USC, United States Code. So that is law that's created by a body of men with the constituted authority to be able to create law. We delegated the power to make law to our representatives in the central government. So we have representatives that come together that create law, right? Statute. But that statute must all comply with the foundational law. If the statute is contrary to the Constitution, it is also unconstitutional. It must be consistent with what the Constitution, delegates, or the power that we delegate. Then above that, and this could also be said within a state, but nonetheless, the state can't exceed any of this. The state can't exceed the United States Code, because the Constitution says this Constitution and the laws of the United States shall be the supreme law of the land. So no state can create a law contrary to the United States Code, because the United States Code is the supreme law of the land, according to the Constitution. And the state gave up their sovereignty when they subjected themselves to the Constitution of the United States of America. So they agreed to this when they joined the Union. Right? But nonetheless, so you have statutes. Then you get into this, and all of that is called positive law. Positive law. So Constitution, treaties, statutes, that's all positive law. It's law that's in a written form and so on, created by a body of men with the constituted authority to be able to create law. Then you get into what's called negative law. Negative law. Negative law is law created by a body of men that do not have the constituted authority to create law. The fact that you call it law is an oxymoron, because it's made by people that can't legislate. This would be your executive orders. This would be the president's executive orders. That's not law, right? Because it's made by a branch of government that can't legislate, because the Constitution only delegated legislative power to Congress. We didn't delegate that to the executive branch. So when the executive branch creates an order, right, and then goes out and enforces it as though it's law, that's not law, right? That's an order. But nonetheless, an executive order would be negative law, because it's made by a branch government and body of men that don't have the constituted authority to be able to create law. Another bit of negative law would be judge-made rulings, Because remember, judge-made rulings is not law either. We didn't delegate the authority for judges to speak the law. Therefore, when judges create a ruling contrary to the law, that's unlawful, right? Because judges can't create law. That's why when we call a judge-made ruling case law, it's once again an oxymoron. Because judges can't make law. They can't legislate. We can't legislate from the bench. So when you create a ruling and call it law, it's not law. It can't be law because you don't have the authority to legislate, judge. But all of this is known as negative law. It would include all of your executive orders. It would include all of your judge-made rulings. That's all part of the negative law. Now, this negative law is common law. That's where common law comes from. So in England, common law is the law, right? That's why when we talk about common law, you're like, oh, well, we follow common law. No, we don't. Not here in America, we don't follow common law because common law is law made by judges. In England, you do follow common law, right? You do follow that. But here in America, we did not give the authority for judges to create law, right? In England, the king did delegate his authority for judges to speak the law, but we didn't do that here. We don't want judges to be able to create the law. Therefore, we don't follow common law. Common law is not considered. We did establish our founding principles based upon the English common law, right? We did establish based upon that, but we don't live in a common law system because judges don't create the law, right? Not here in America. We did not delegate that authority. We don't want judges to speak the law. What they create is not the law. The law is created by the people, right? That's what they do in England because the monarchy did delegate that power to his judges, but we did not do that here in America. The Constitution does not allow it. So all of that would be your negative law, common law. Now, the lowest form of common law, the absolute lowest, is known as judge-made rulings, right? Judge-made rulings is the exact opposite of the Constitution. So if the Constitution is the foundation, the opposite of the Constitution in the hierarchy of law is a judge-made ruling. And the reason why is because constitutionalism is based upon suffrage, right? So it takes the majority of the people to make an amendment to the Constitution. That's the way that constitutionalism works. So it requires the majority of the people to change the Constitution in a very, very specific way. So if the majority of our society is necessary to change the law, then the opposite of constitutionalism would be one single person imposing his will upon the rest of the nation. That's why a judge-made ruling is the exact opposite of constitutionalism in the hierarchy of law. The Constitution requires majority decision. A judge-made ruling is one judge saying, I don't agree with that. Therefore, this ruling is now law, and we're going to follow my ruling as opposed to the law. And that brings me to this. There are basically two opposing political doctrines that exist. One is known as the government of laws doctrine. The other is known as legal realism doctrine, okay? And they are absolutely opposing views, and this is what we're experiencing here in America right now today. We, the people, are under the belief that we live in a government of laws doctrine. Because the government of laws doctrine is constitutionally based. And it's built upon the theory that in order for laws to be legitimate, they must be considered just and equal. This is the egalitarianism approach which our Constitution is framed upon, right? But in order for all men to be equal, government and laws must treat them equally, right? This is the way that our system is designed to work. It's based upon a fixed set of laws or principles in which the courts and people adhere to and to which every person is accustomed to, okay? So the opposite of government of laws doctrine is the legal realism doctrine, which is very much alive and at work here in America. It's destroying our system of government. And it's the belief that law is not based upon a formal set of laws or principles, but instead upon judicial decisions. That's based upon that judge's individual political, public, or social policy. That means that judges make the law. That is a doctrine known as legal realism. That law is not based upon a formal set of laws or principles, but instead upon judicial decisions that derive from their own social, political, or public policy. But this is not constitutionally based, right? Instead, it is judge-made ruling based, right? which means that the system that was intended to have the Constitution at the foundation has been flipped upside down by the judges. And now what's at the foundation is judge-made rulings, which means that the opposite of the foundation is now the Constitution at the top. And the reason why I bring that up is because when you walk into a courtroom today and you say, "Judge, my rights have been violated," where does that judge go to determine whether or not your constitutional rights have been violated? Does he go to the Constitution, or does he go to a judge-made ruling? He goes to a judge-made ruling, which means that the foundation, what they're relying upon, is the exact opposite of the Constitution. They're going to this because they want to be able to make a decision based upon their own social, political, or public policy, which is the legal realism doctrine, not the government of laws doctrine. We can't live within a fixed society and have a predictable future and outcome because the system that we're operating within is based upon a judge's own social, political, public policy, because they placed judicial rulings at the foundation and have removed the Constitution, which means that judges are able to amend the Constitution of the United States through their own judicial rulings. You don't get an indictment by a grand jury because this judge in 1884 said you don't have to, right? You don't get to see your children because this judge-made ruling from 1884 says that you don't. Whatever that might be, that judge is able to determine their own outcome of the dispute, and they're able to reach that outcome of the dispute based upon this massive body of law known as common law, known as judge-made rulings, and they can reach any predetermined outcome that they want based upon these judge-made rulings. You're not able to rely upon the law because the law is not the foundation. Judge-made rulings are the foundation. And now, you can't live in a predictable society because what you're relying upon is the flawed decision of the man that came before that judge, or the flawed decision of the man that came before that judge, right? And this is a system where judges make the law based upon their own social, political, public policy. This is an English, British system of government that is inconsistent with what the people of the United States established through the Union and the Constitution of the United States of America. Judges have intentionally removed the Constitution from its foundation and rightful place, put into place their own judge-made rulings, and now we live in a world where judges make the law just like they did in England under a king and a monarchy, right? And they're able to remove the limitations of power that we, the people, protected in order to preserve our own individual liberties that was designed within the Constitution of the United States of America. This is exactly what is happening, and this is what we're trying to fix. So last year, remember, we had the Chevron ruling, June 28th of 2024. The Chevron ruling came into place, and the Chevron ruling was all about, does the judicial branch have the authority to create their own law, right? And go out and enforce it as though it's law. And they did it, right? Because remember, the Chevron doctrine was all about if an executive officer believed that the law was ambiguous, that it wasn't clear, right? That it was ambiguous, that they were able to write policy, executive orders, right? That would clarify it, and they would defer to the agency in this. And then they would write their policy, and then they would go out and enforce that policy, based upon, the clarity that it would provide. The problem is that, once again, does the executive branch have the constituted authority to be able to legislate? The answer is no, because Clause 1, Article 1 says all legislative power is vested in Congress of the United States. The people create law, executive branch creates policy and orders, right? So, the whole issue with the Chevron doctrine was, if you aren't clear, executive officer, as to what the law requires, and you believe that the law is ambiguous, then you must go back to the branch of government with the authority to legislate and get clarification. You don't get to create your own policy and then go out and enforce that as though it's law, because that would be unlawful, right? It would be a branch of government that doesn't have authority. So we got the ruling in Chevron last year, but if we want to get the Constitution, because remember, the foundation right now is judge-made rulings. Constitution is at the top. It's not where it's supposed to be. It was meant to be the foundation, and instead these judges have taken it and put it at the top, and the foundation is their judge-made rulings, which means that they are violating the Constitution of the United States every single day because they're not going to it to determine outcome of dispute. They are relying upon a judge-made ruling as the foundation and not the object of which fidelity is bound, which they promised. So we want to get the Constitution back to the foundation. We had to do two things. All this negative law, it all had to get destroyed. The first half of the negative law, again, was the executive orders. The executive branch does not get to legislate. They make policy. That policy must be consistent with the law because the executive branch cannot create law. We got that through the judgment, through the Chevron ruling, right? I know that we don't see it in place yet, but the reason why we don't see it in place yet is because there's something else that has to be removed before the Constitution will fall back into its rightful place, the foundation. And that is all of the judge-made rulings. Judges, you don't get to create law either, right? So when you create a ruling, that ruling must be consistent with the positive law, because otherwise you are overstepping the separation of powers and legislating from the bench, and you don't have any constituted authority to legislate. So if we want the Constitution back in its foundation, we got to remove first all the executive orders, all the bullshit policy that the executive branch put into place, and we got that with Chevron last year. What I'm working on is the second half, and that's the judicial branch. The judicial branch doesn't have the authority any more than the executive branch does to take their rulings, place it at the foundation, and then be able to go out and enforce that as though that's law. Rulings is not law, right? Rulings is an opinion of a judge that must be consistent with the positive law, because judges are tethered to positive law. So we've got to get rid of all of the judge-made rulings, including Supreme Court. It's got to go away. Boom, get rid of it. And when we do that, then the Constitution of the United States of America will fall back into its rightful place at the foundation, and then we will see a government of laws once again, where the judges are no longer able to govern us whatever way they see fit based upon their own social, political, or public policy, right? And that's what we have to overcome. That's what we're working on here. And this is a huge animal, especially considering the fact that, that I'm only one man, and 9 years ago I took this on, and it's taken me years to get a following here. I mean, we've had good participation in both TikTok and Facebook. I've had 100 viewers on Facebook mostly the whole time. We've had about 60 to 70 here on TikTok. I mean, this is a good participation. 160 people is watching this 2-hour video. That's awesome. Thank you guys so much for doing that. But it's taken me 9 years to get to this point. 9 years, right? And so, for many years, I've had to go out and I've had to just raise awareness on this issue, trying to get people to understand the basis of these issues. And I'll tell you, 9 years ago when I started this, and I said that the state can't be both accuser and judge in the same cause because Article 3 doesn't allow it, I can't tell you how many people laughed at me, right? Told me I was crazy, didn't know what I was talking about. But I knew what I was talking about because I know the law. The law says it. It's written right here. In all cases which a state shall be party, Supreme Court shall have original jurisdiction. The state cannot be both accuser and judge, because if they do, the state loses jurisdiction. This is a simple concept, but it's taken me years and years and years to get to the point where you guys are actually hearing what I'm saying and understanding it, right? And so, but it's taken a long time to get to this point. And so, I was on earlier today and what's her name? Angela Sutton. And I saw one of her videos on TikTok, Angela Sutton, and she was talking about how, the state can't be accuser and judge in the same, because the state can't be your accuser. But the problem is that she's simply echoing the things that I'm saying here. She has a much bigger following base than me. Like, I've got 32,000 here and 40,000 here and 2,000 over here on YouTube. I mean, I don't have a huge following base. She does. But she's only bringing and echoing one small part of the things I'm saying. She's not bringing the law that backs it up. I can say to you guys, the state can't be both accuser and judge in the same cause. But if I don't tell you why and where in law it backs it up, to what value is that to you, right? And so, I see a lot of these copycat people coming in, and they're taking the things that I'm saying The whole plea bargains. Plea bargains are unconstitutional because they're compelling a result to illegal means. They're forcing you to act as a witness against yourself, right? But they're saying, simply, oh, it's not lawful, or the state can't be the accuser, or original jurisdiction of the Supreme Court. Like, they're bringing up these issues that I have originally submitted to the Supreme Court, the issues that I've been talking about for years here, that I was laughed at for 7 years, that I've had to battle through to try to raise awareness on this issue to all of you. But they're not bringing with it the law to back it up, right? And that's not beneficial to all of you, right? I would like Angela Sutton and some of these other people, Lawful Patriot, I'd like them to actually point you back to me, because I am the one that knows the law. I'm the one that brought this up. They're simply echoing the things I say, but they're echoing it in a very, very small element without telling you where it's at. The reason why plea bargains are illegal is because of the self-incrimination clause of the Fifth Amendment. No person shall be compelled in any criminal case to act as a witness against themselves. The definition of compelled is to bring about through the use of threats or intimidation. So if you threaten or intimidate someone to act as a witness against themselves, that would be a violation of the self-incrimination clause. And when you sign a plea bargain, down at the bottom of it, it says, I did certain things, and you sign it, which means you were acting as a witness against yourself. And the way that they get you to do it is through the use of threats or intimidation by saying to you, if you don't plead guilty, I'm going to send you to prison for 20 years, right? Now you are compelling a person to act as a witness against themselves. That's what you guys need. That's the information and knowledge that you need to be able to back up the echoing that these people are bringing, right? But if they just say to you, yeah, it's not lawful for the state to be both accuser and judge, well, they fail to bring in the understanding that Article 3 of the United States Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, right? Meaning that the state can't have jurisdiction in a case in which the state itself is a party. But if you don't bring that information, if you don't back up the words and you just echo it, but you don't back it up with the law to be able to give to all of you, then it's not really beneficial to you. I want you guys to have the law. But in order to do that, you guys gotta, people have to go to the source, have to understand it. So, I've been talking about these things for years. 9 years I've been building this case, and the case has never changed. I've never changed what I'm saying. It's been consistent the whole time. I submitted this case to the United States Supreme Court in 2019, right? We're waiting to reach a point where the Supreme Court can't ignore this anymore. And when we do, then we will have this case heard, and I will be arguing and litigating this on your behalf, because that's what I did. I brought this case in 2019. I had more than 4,000 people in the state of Washington petition on the exact same issue. And this issue is Article 3, can a state be both accuser and judge? Can the state compel you to act as a witness against yourself? Is the 13th Amendment valid under the exception clause and the forced involuntary servitude? And are states able to enact their own alternative legislation, substitute it for the guarantees of the Constitution, go out and enforce it? All of which is not valid, right? But those are the 4 grounds that we have. Those are the 4 things that we're going to be litigating. And so, because I originally submitted this in 2019, I am the petitioner, right? And the first petitioning party is the party that will be arguing this. So no one else has to bring this case up. No one else has to do it. All I have to do is get out here and continue to raise awareness. And so I do appreciate Angela Sutton and Lawful Patriot, these other people that are starting to echo the things I say. But the thing about it is that I'm not doing this for likes or follows. I could give a shit about the likes or follows. I appreciate them doing that so that they can make money and, whatever the likes and follows they can get. That's great. That's wonderful. But if they don't point people back to me, right, to be able to back it up with the law, then it's not doing the people any good, right? So I don't want the likes and follows. I don't care about money. I'm here to get this job done. And that was always my intent. And so a lot of these copycats, it's great that they're spreading this information. They're sharing it with their base, but unless they point it back to the petitioner and the source, right, then those people aren't getting what they need to actually benefit from the knowledge, right? If they don't understand why the state cannot be a party in the cause because the law says it here, then that doesn't do any good. If they don't know why you can't be, threatened, intimidated, and forced into pleading guilty, right, then it doesn't do them any good. So I'm hoping that, This is actually what's necessary. In order to get the United States Supreme Court to hear this case, we have to spread this information. We have to raise awareness on the issue to reach a point where they can no longer ignore it. That is what we have to do. But it would be a whole lot easier if we were able to do this together and not just simply, take some of the things I'm saying and then say, well, that makes a lot of sense, but I don't know why. It's just I'm going to go and make a video and say, well, this makes a lot of sense. Yeah. State can't be accuser and judge in the same cause, but the reason why is because the Constitution bars it. And James Madison stated in the Federalist Number 10 about it. Alexander Hamilton stated in the Federalist Number 80 about it. Martin vs. Hunter's Lessee stated it in it. The Automatic Recusal Code, Title 18, USC subsection 555 forbids it. I mean, all of this is information that people need if they want to benefit from a statement that, a state can't be both accuser and party in the same cause. So, I would hope that they will start pointing people in my direction, because it's not really doing any good for them to simply take the likes and follows, take some of the things I'm saying, especially after years of fighting against me and saying that I'm wrong, and now they're all saying that I'm right. Well, I knew I was right. That's why I continued on and trudged down this path without skipping. So, all right. So I have one thing left on the list here I want to talk about, and that is, so the Supreme Court of the United States, they have a long history, guys, a long history of making decisions that are not in the best interest of people, right? So when we go back to the Hans versus Louisiana case, right? Hans versus Louisiana. Why did the Supreme Court of the United States say that the states are sovereign? Why, right? It wasn't because it was the right thing to do, right? It wasn't because it's in the best interest of the people. It's because it's in the best interest of the corporation, right? It's because we run government as though it's a business. And if we run as though it's a business, then the decisions that the business makes is going to be what's in the best fiscal interests of the business and not what's in the best societal interests of the people. Because the people's rights and the people's needs are in conflict with the fiscal interests of the corporation. As long as government is a business and ran as though it's a business, then the decisions and laws that are enacted is going to be at how much money can we generate in revenue, because a business must always generate revenue. So you have to understand that government is not a business, but the way we run it today is that it is, and that means that the decisions that are made, the laws created, the rulings enacted are in what is in the best fiscal interest of the corporation. We need more money going to the corporation because that's what corporations do. They make money. So the more money the United States corporation makes is in the best interest of the corporate holders, right? The decision makers within the corporation. So the Supreme Court doesn't make decisions that are in the best interest of the people. They make decisions that's in the best interest of the corporation. So like, for instance, the Hans versus Louisiana case, right? Why did the Supreme Court of the United States say that the states are sovereign? Well, that's because the 13th Amendment was the amendment that was enacted in 1865, immediately following the Civil War, that supposedly abolished slavery, right? Supposedly abolished slavery. So we think that slavery doesn't exist anymore, right? It was abolished in 1865 after the Civil War, and the 13th Amendment was enacted and ratified and adopted by the people so that slavery will never, ever, ever exist here in America ever again, right? That's what we believe, right? That's the belief of the people of the United States. But that's not what was enacted, right? What the 13th Amendment says, it does not say that you cannot have slavery. What it says is neither slavery nor involuntary servitude shall exist except as the punishment for a crime. Except as a punishment for crime. So the problem is that when you say except, it means that you can have slavery as the punishment for crime, right? Neither slavery nor involuntary servitude shall exist except as a punishment for crime. So you can enslave a person and force them into involuntary servitude, right, as the punishment for crime. So it's the state that became the slave owner under the 13th Amendment. The 13th Amendment doesn't say you can't have slavery. It says slaves are criminals. And we can look at the history of our system to understand that this is the truth. Because when you look at the Fugitive Slave Act, a fugitive is a slave, and a slave is a fugitive. Those two terms are synonymous with one another. They mean the same thing. Then the 13th Amendment says that if you're a criminal, you're a slave, right? That means that if you're a fugitive, you're a slave. So here in America, our system of government has always believed that criminals are slaves. Fugitive are slaves. Slaves are criminals, right? And thus the state became the slave owner under the 13th Amendment. 13th Amendment simply transferred slave ownership from private party into public party, right, under the state, and the state became the slave owner. That's why the state actually makes money off the involuntary servitude of the criminals that they put into prison. That's why down in Florida, we have prisoners that build the chipset for General Dynamics fighter jets. The prisoner don't get paid a cent. The state of Florida gets paid through a contract with General Dynamics that they will provide the labor for this work to be done. That's not justice. That's slavery. And the slave owner is the state of Florida, because the slave owner is the one that's benefiting from the forced involuntary servitude of the people that they slave out to the for-profit businesses. You have the state of Florida that also contracts with with Northrop Grumman to answer help desk phone calls for a for-profit defense contractor. The prisoner doesn't get paid a cent. The slave doesn't get paid a cent. The slave owner, the state of Florida, gets paid through a contract between Northrop Grumman and the state of Florida. We have in Georgia the female prison that sews tags on Victoria's Secret underwear. Those women slaves or prisoners don't get paid a cent. The state of Georgia does, because the state of Georgia has a contract with the for-profit company to do this work and to force involuntary servitude these people into the institution to do it. That's not justice. That's slavery, right? We also have McDonald's in Texas, where the prisoners make McDonald's hamburgers. We also have in the state of Florida, more than 870 prisoners that are out fighting fires for the state of California, right? They get paid pennies an hour, dollars every day, like $5 or something every day to do this work, right? That's not justice. That's slavery. That's forced involuntary servitude, right? And so my point here is that in 1865. Prior to that, in chattel slavery, you had private parties that owned the slaves, right? You had Bill's cotton picking plant down in Louisiana that was the slave owner. But after the Civil War, the slaves fell under the property of the state. Now the state is a slave owner, and the state contracts, right? Contracts. This is convict leasing. They lease out convicts to go and do work for-profit companies, and the convict doesn't get paid a cent. The slave owner gets paid, right? So why did the Supreme Court of the United States make the decision in 1890 that states are sovereign? Because in making states sovereign, the slave cannot sue the slave owner in federal court, because the slave owner is now immune and sovereign, right? If the slave is able to take the slave owner, the state, into federal court and sue in federal court for their freedom, then that would mean that they would open up the door, the floodgates to the slaves overcoming their slave master. So in order to preserve the slavery institution, the Supreme Court of the United States said, okay, we got to make the slave owners immune, right? So that the slaves cannot sue in federal court for their freedom, and thus we can preserve the institution long term. That was the reason why the Supreme Court of the United States made this decision in 1890. It has nothing to do with the interests of the people. It was all about preserving and memorializing actually the Dred Scott ruling from 1857, where they said, slave, you don't have standing in federal court because you're not a person, go away. And thus, Dred Scott lost and Sanford won, because they said the slave can't sue his master in federal court because you're not a person. So they made this decision once again in Hans versus Louisiana in 1890, and that's the reason why they did it. It's not because it's in the best interest of the people. It's because it's in the best interest of preservation of the institution, because government is in the business of enslaving the people. That's what justice is. Justice is the enslavement of the people through adjudication, right? And so it was not made for the right decision. But these decisions that the Supreme Court makes is what is in the best interest of the corporation. And we can see that from many different rulings. Another great ruling, and I don't know why I wrote this one down, but I wrote it down because I wanted to mention it to you guys because, you know, a lot of you are talking about how the state is a corporation. It's not a living, breathing person. They can't bring a case against us. And I agree. I agree, except for the Supreme Court of the United States in 1886 under the case Santa Clara County versus Southern Pacific Railroad made corporations granted personhood. Okay? So the history behind this was, and again, this is the same court. Everything we're dealing with is the Waite Court. The Waite Court was a science experiment. Hurtado versus California, slaughterhouse cases, the Southern Pacific Railroad, Hans versus Louisiana. This was all the Waite Court. And Waite Court was all about preserving the slavery institution because they were all slavery sympathizers, right? And so every one of these rulings, we're actually having to go back to the Waite Court, and that's what we're challenging. I mean, we're going to impeach the entire Waite Court for these rulings that they made by overstepping separation powers. But what happened in 1886 under this Santa Clara County versus Southern Pacific Railroad? So Southern Pacific Railroad was being sued, right? They were being sued by Santa Clara County. And before the oral arguments were presented to the United States Supreme Court, Chief Justice Waite stated to the press that was there and to everybody in the audience, he said that all of us, we are under the belief that this corporation is protected under the Equal Protection Clause of the 14th Amendment. This statement had nothing to do with the case. Nothing to do with the case, right? It was just an arbitrary statement that Chief Justice Waite made prior to the oral arguments even being stated. But this one statement has such a profound impact on everything that you guys believe is happening. And once again, it was just an arbitrary statement. And again, what he said was, he said, we, and he's referring to the rest of the justices that were there, we are under the belief that this corporation is protected by the Equal Protection Clause of the 14th Amendment. What happens there is that, remember you guys, the Constitution and the purpose of the Constitution is to preserve rights and limit powers. Preserve rights and limit powers. People have rights. Government has powers, but the powers are specifically limited in order to preserve the individual rights of the people. That's what the Constitution's purpose is. So the Constitution protects the people's rights from government's powers. Okay? So why this is so profound is that when the Supreme Court, when Chief Justice Waite said, oh, this corporation is protected by the 14th Amendment, well, that means that corporation is now a person because only people can be protected by the 14th Amendment. The Supreme Court granted corporations personhood by that one single statement by saying this corporation is now protected by the Constitution. And ever since then, we've been under the belief that corporations can be people, right? Because they were granted personhood by this arbitrary statement. Now, the Supreme Court, and Chief Justice Waite, he didn't make that decision because it's the right thing to do. Like, oh yeah, corporations need to be protected by the Constitution because they're people and they're granted. That wasn't why he did it. The reason why he did it was because states are nothing more than corporations, right? The United States of America is nothing more than a corporation, right? So if we want to protect the corporation from the prisoners being able to sue, we need the corporation to be granted personhood so that the corporation has rights. The reason why is because only people can own property, right? Only people can own property. So if they want to protect the slavery institution by ensuring that the property of the state or the property of the slaves is protected, then we have to make the slave owner a person, because otherwise corporation can't own property, and thus the slave would be able to sue. So in order to preserve the institution, once again, they needed to grant corporations personhood so that the state is able to be protected by its property, because just as Dred Scott versus Sanford says, slaves are private property protected by the Constitution. So when the Supreme Court made the decision that corporations are now granted personhood, then that means that the state is coming against you in a criminal matter as a person because they were granted personhood, right? The state of whatever is, according to the Supreme Court, a person because they were granted personhood in 1886, and therefore that person can bring a case against you as a person, right? And so if you guys try to argue this, right, without understanding the lawful foundation, without understanding the deception that the Supreme Court of the United States put into place, you're going to lose these arguments, right? You're going to lose. Because when you say the state isn't a person, well, that's not what the Supreme Court said. But what I can say is that the Constitution says in all cases in which a state shall be party, the Supreme Court has original jurisdiction. You can't argue that the state isn't a living, breathing person because the Supreme Court granted them personhood. Now you can have a state be accuser against you, but the problem is that the state can't have jurisdiction over itself because the Constitution didn't grant the state jurisdiction in a case in which the state is a party, right? That state is a body of men. And when that body of men comes against you as the state, all parts of the state, every single part of it, be it prosecutors, law enforcement, judges, they are all part of that body of men that make up the state. And that state is one person, not 50 people. And if it's one person, then that means that that person, right, is no different than any other person. And that's where you get the, right? Yes, the state is not a living, breathing person. And yes, you need to have an accuser, right? But when the Supreme Court granted the state personhood in 1886, if you come with that argument, you're not going to get anywhere with it, right? You have to rely upon the Constitution. And so I want to leave you with this, right? If I could give you, right? Some of you know my background. Some of you guys know my history. I'm not an attorney. I don't have a degree in adjective law. I will never be an attorney. I don't want to take the bar. I fucking hate courtrooms. I hate judges even more than I hate courtrooms. I am law enforcement. My degree, my master's, my first one was in substantive law. I have a master's in substantive law that I got at George Washington University. I graduated with a 3.98 GPA with distinction on the South Lawn of the White House. I know law enforcement because my degree is in law enforcement. I know how to build a case against criminals and I know how to prosecute a case against criminals. My degree is in law enforcement. So if you want to know how to hold criminals accountable for crimes, that's what you'd come to me for, right? I don't know about courtrooms. I fucking hate courtrooms. I hate judges. I hate that shit. I don't like going in them, right? But I do like building cases against criminals, and that's what we're doing. We're building the biggest criminal case against the biggest criminal racketeering enterprise that there is in history of the world, known as the United States of America and all of its subsidiary corporations. That's what we're doing, right? But you know, that's my history. I also have a master's in forensics, right? You guys know that. I graduated with the same there. So I know law enforcement. I don't know courtrooms. But I know law enforcement. I know how to enforce the law, right? But if I could give you, I went to the most expensive university in the United States for my master's in forensics. If I could give you $200,000 worth of education in one single sentence, it would be this. Anything that is not the Constitution is unconstitutional. Simply by virtue of the fact that it is not the Constitution makes it unconstitutional. So when you want to bring an argument to me and say, the state statute says this, I'm going to say, yeah, but the Constitution says that. When you bring to me a judge-made ruling that says this, I'm going to say, yeah, but the Constitution says that. When you say to me, United States Code says this, I'm going to say, Constitution says that, right? Because I fight from the Constitution and what it says. And I will back up the Constitution with statutes that are constitutional. I will never back up the Constitution with judge-made rulings that are unconstitutional, or statutes that are unconstitutional, or inferior state provisions. I will not do it because I fight from the highest form of law, because anything that's not the Constitution is unconstitutional. So the only law that I have to cite, the only law I have to know, the only law I have to quote, the only law all of you need to quote or know or understand is the Constitution. And if you fight from it, nothing that anyone brings up can beat it. So when the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. All that I have to do is, when they say Hurtado versus California says you don't have to do it, I will repeat what the Constitution of the United States of America says. They can't win. When I cite the Constitution and they bring up the state of Washington's inferior state constitutional provision that says they don't have to do it, I'm once again going to cite the United States Constitution. Anything underneath that is contrary to it is unconstitutional. So when you get up on the highest form of law, right? They put the Constitution at the top. The Constitution was meant to be at the bottom, but they completely inverted everything. When you get up on the highest form of law now, you get up on it. You don't come down off of it to fight down in the weeds, down in case law, or down in the weeds in state statutes, or down in the weeds in treaties and ordinances and customs. You don't come down off of your high position because there's a military philosophy that whoever holds high ground has got superior tactical capability. When you get up into the high position and the highest form of law, you don't come down off of it to fight where they want you to fight. You draw them up to you because these judges cannot fight at the highest form of law. They cannot fight against the Constitution with their statutes, their ordinances, and their judge-made rulings because none of that can be contrary to the Constitution of the United States of America. So what I would say to all of you is get up on the Constitution. Read the 4 pages of the Constitution, learn it by heart, cite it by heart. And when you do, you will overcome and prevail in whatever it is that they're doing with you because they can't fight at your level, right? Once you know the Constitution of the United States of America, nothing else can defeat you, right? Nothing. You will be able to find an argument to be able to overcome any matter that they bring against you because any matter that they bring against you is intended to reduce and limit your freedom, which the Constitution was designed to preserve, protect, right? So if the Constitution is there to preserve your liberty and your rights, then all of the laws and rulings and customs that is intended to arbitrarily use the power to eliminate or remove or take away your rights, they lose their power. There is no power in it because that's what power is. Power is the mechanism that is used to eliminate or remove individual freedoms, right? So power is actually subjected to liberty, right? Liberty is power is the mechanism used to remove liberty, but the Constitution is intended to preserve the liberty. So when you use the Constitution, you provide the check on the power in order to preserve your individual freedoms. And that's what the Constitution was designed to do. And so if I give you guys one piece of advice out of hundreds of thousands of dollars for of education, anything that's not the Constitution is unconstitutional simply by virtue of the fact that it is not the Constitution. Okay? Anything that's not the Constitution is unconstitutional. Don't rely upon it. All right? Thank you guys so much. All right. Thank you guys so much. I'll read through some of these messages here. YouTube, I'm going to try to get a little bit better on working with you guys. I now have a third device, so we've got we're going out to 3 different places, and I don't have a subscription to StreamYard. If you guys want to donate to help move this along, be advised that Jessica's Cash App was shut down. They shut it down without justification of cause. Haven't allowed her to be able to start it up. Jessica is here with me. We do work together. Everything we do is together, and so you're not able to donate to Justice Without Limits, right? Cash App has been put down, but you guys can, if you want to donate to me, you guys put a note there saying to Jessica, and I will get her the money. But do understand.
It all goes to the same place.
It all goes to the same place. So
yeah, it all goes to the same place, and all of our Cash App details are on the website. So justicewithoutlimits.org, and then go to the operations tab. I made everything transparent. You guys can see where the money is going. We operate on very limited funds. I put some gauges in. The gauges are connected to a spreadsheet, but I have to manually input it in. So if you go and you donate $100 or $500 or whatever, I have to go in and update that. So you'll see the gauge move, and if you're donating towards, food, travel, whatever the other two were, miscellaneous, and then I think I had like technology, like we have phone bills, obviously. But if you go and you donate to one of those, just put it in as what you want it to go towards, and then I'll have to go in and manually update it, and then you'll see the gauges. But the gauges are where that's the most transparent way that I could try to put it out there, that this is how we're operating. So that's it. Oh, can I talk about the heat maps?
Yeah.
Okay, so we have heat maps now on the website, and I have a video that I'm about to post about that. So if you go to Justice Without Limits, go to the homepage. At the very bottom, there's two different heat maps.
Over 200 people.
The heat maps so there's a heat map on the left. That is a heat map that talks or it corresponds directly to how many people have filled out the National Family Survey, the one that we started back in Arizona after I served Maricopa County and against Judge Melissa Zaber. Melissa Zaber stepped down, by the way. She recused herself from 3 different cases in that county, and one of the cases was the one that I served on behalf of the affiant. So we are getting traction and people are listening to what we're saying. But if you go to the website, the heat map on the left, that's how many people in your state have actually filed reports stating that they are willing to go and testify before a federal court that the things that they're saying are true and accurate regarding the deprivation of rights under color of law regarding unlawful removal of your children. The heat map on the right is very interesting because now all of a sudden the colors are changing. That is a heat map that's based on relativity. It's based on per capita and population. So we've gotten 180 some responses out of Florida, for instance. So Florida right now, if you look at the heat map, that's the hottest state. You would look at it and think, oh my gosh, Florida's the worst. When you look at it per capita as an index, you would see that West Virginia is now popping up as the hottest state. And that's interesting because I was speaking with someone earlier today and he was like, well, West Virginia is the poorest state. So that would make sense. So there's some more, I would call it, I guess, forensic investigation that we're doing about some of these states and counties, the hotspot states and counties. But guys, keep pushing that national survey regarding your family court because we're going to be able to use that. As a matter of fact, the numbers that we have now, we just crossed over 2,000 respondents, but not 2,000 individuals. So what I want to be able to do is have 2,000 individuals. And I'm glad that you guys, many people are in multiple counties. And so I'm really glad that you are coming and filling out the form and specifying the different judges in the different counties. That's fine. But to have a proper sample size, we would need 2,000 individuals, not necessarily 2,000 responses. And so with that, I think that we're sitting at about 1,800 responses. So we still need a good 200. But guys, this is just a drop in the bucket. We should have 5,000. We could have 10,000. And some of this is just getting the information in front of people. So please continue to share. Please continue to collaborate with people in your local communities. Send the website. I say it all the time on the private Zoom meetings. This is not my website. This is not Tanila's website. I am taking constructive criticism in from people all over the country, and they're telling me that's why they were like, hey, you need to create an operations page so that people know exactly where your money is going. And so that's what I did. So if you have constructive criticism or things that we need to change on the website to make it better, please get back to me. This is not my website. This is all of our website, and we're going to use this. I'm also, we have contributors now. So if you're interested in writing articles and you want to contribute to the blog page, please go to justicewithoutlimits.org, the contacts page, join the movement, and we need some contributors. I've already gotten, I think, four different articles from 4 different contributors, and they're freaking phenomenal. And it's just going to push this information out even further. So we're doing that. You should get my emails. I send the emails out for the Zoom, the private Zoom. I send them out on Sunday morning. And the reason is because I'm giving people as much time possible that maybe are just now catching wind of what we're doing so that they can go on and fill the information out and get onto the email list. So I wait really up until the very last minute just in case there are some, stragglers for the week that want to come and join us on the Zoom. So check your spam. If you have filled out any of those forms, check your spam box, your social box. Some people are saying that they found it in a promotion box. So I guess the best way, if you're not getting the emails and you know that you've signed up, is go to your search engine on your email browser and just type in my name, because I put my name at the end of every email. Just type in my name and then that should pop up. And also, the Zoom link hasn't changed for the last couple of weeks, and so I have it on my Facebook as well. And tomorrow I'll pin it at the top. I'll pin it at the top so that it's easy for people to find if you guys, and it's easier for you to share as well and get people in there. I'm also gonna have to lock Zoom down because we keep people. I always try to make it so that people can talk. What I'm finding is that the people that come in and want to disrupt, they're not willing to stick around for an hour or an hour and a half in order to actually help people and care about other people and listen to other people's cases. So they don't stick around. So I'm gonna just lock the Zoom down. I'm gonna lock all of the mics down, videos down at the very beginning. We're gonna get started. I will open it up about 10 minutes early, but 4:30 Eastern, 3:30 Central, 2:30 Mountain Time, 1:30 Pacific. And I'll have the mics, everything locked down. We'll go over the county commissioners serving. I have created a form. I haven't made it public yet, but I have created a form so that we can start counting. Guys, did you tell them about the 60 million?
No. I've told them about 7 million before, but yeah, go ahead.
Can I? Okay, so we added up all of the counties that we've provided serve, not just us, but other people like Toes. There is Sean Cervantes out of California. There's Shayna in Oklahoma. There's
Lydia up in North Dakota.
Lydia, Mira.
Regardless, there's a bunch of people that are also.
I don't want to miss anybody because there's a lot of people, but we have effectively provided notice on behalf of more than 60 million people in America. That's freaking huge. And that's just a drop in the bucket when you consider the counties. I'm still on a tear, guys. We still want to get the 3,143 counties, all of them served.
Well, what she means there is that when we go into a county commissioner meeting, right? For instance, the LA County. When we went and served LA County has 10 million people within that county. Those 10 million people are currently subject to arbitrary and capricious arrest because the state of California doesn't follow the Constitution, which means that we effectively advocated on behalf of 10 million people in that one single service. And then like Cook County in Illinois, we served on behalf of 6 million people, or Maricopa County, 5.4 million. So, as we go in and we do this, these are people, most of these people don't even know that they need to be advocated for because they've never been subjected to the system. And yet that's what we're doing. We're going in and we're literally speaking on their behalf in this legal matter. And so today, right now, as we speak, we've spoken on behalf of more than 60 million people across the United States of America through these services that we've done.
Yeah, it's really big. And so, but we're just getting started. I mean, how many people are in America?
330 million people, and my goal was to reach half of them. Half of them would be about what the Supreme Court would want to see, But again, like most of these people don't even know that they need to be advocated for, right? An advocate is defined as one who speaks on behalf of others in a legal matter. And that's what we're doing. We're speaking on behalf of the people of the United States in this legal matter because the people of the United States don't even realize that their rights are being abridged by governmental overreach of power, right? So, that's what we have to do. And she wants to do all 330 million. We'll do whatever's necessary to make it to the Supreme Court. That's if we have to do it on behalf of every single person, then that's what we've committed to and that's what we'll do. But the whole point is that this decision has to be made by the Supreme Court of the United States because the Supreme Court is the entity because the Supreme Court is the entity that made the decision that the states don't have to follow the Constitution. So whatever's going to be necessary, however many people we have to advocate for, we will advocate and we'll reach that point. If it's 330 million, then Jessica will be right.
Let's freaking do it. I'm ready to go do it. Daniel, you want to join the response team, please do. Just go to the website. It's justicewithoutlimits.org. You can go to my Facebook page and there's some links on there, but go there and fill out the join the movement and you'll be in. Oh, another thing, the contact cards. So last week on the private Zoom meeting, I asked a couple of things. One is, I had some previous requests about creating an overlay, like a Facebook or a TikTok profile overlay of Tanawaz flag. I kind of stole it and started using it on my Justice Without Limits logo, but they wanted the flag overlay with kind of a fade, but something that you could put over your profile picture. And so everybody on the Zoom last week, which we had 70 people last week, 170 people the week before, but they all said yes, please. So I've got those finished. We're going to be releasing those as well as covers for like your cover photo on Facebook or LinkedIn or some of, I guess YouTube has that as well, just so that we can start spreading awareness, because one of our biggest issues is getting to new people. I mean, when I posted my video about court just yesterday, I had people calling me from Blount County. I thought I had, picked through Blount County with a fine-tooth comb, and I've gotten 3 calls today from people from Blount County just saying, I just found you. I had no idea you were doing this. So we're running into an issue just getting the information to people. And so collectively on our Zoom, everybody was like, yeah, let's do it. I want a profile overlay and people can ask. And then another thing is we're creating connect cards. If you're interested in being a leader in your state, join my fan club. Thank you. If you're interested in being a leader in your state or your county, I will create a connect card. It's like a business card, but this isn't a business. This is something that nobody has ever done. But I'm just going to call it a connect card. And you can do that. So join the Zoom tomorrow, and then that's kind of a private link to fill that out because I'm trying to vet people along the way. I love the glasses. Thank you. So anyway, that's it. You are awakening an ignorant giant. Yes, we are. The Zoom meeting is tomorrow. It's every Sunday at 4:30 Eastern, 3:30 Central, 2:30 Mountain Time, and 1:30 Pacific. Tori, how can you speak with me? Whew, how many people do we have on here?
200.
A lot. Tori, you can text me. My cell number, all you have to do is just Google me and my cell number just pops up everywhere. So you'll text me. But guys, I'm getting responses and people being super aggressive with me because I can't respond back. I have over 2,000 messages on my personal phone, not counting the TikTok, not counting the Facebook, that I haven't seen. And it's not because I'm trying to be neglectful. I have so many things that we're trying to do. I just don't have time, especially when people send me a book. I don't have time to read your books. So if you wanted to connect with me, Tori, yes, I would love. You're in Sevier County. Okay, I would love to connect with you guys, but I need you to be patient with me. Like, I was getting super aggressive text messages. One person, and he apologized, but I'm going to use him as an example because he apologized. But he would message me and he was like, well, if you're not going to respond, I guess I'm going to block this number because you don't care. And I'm like, no, dude, I do care, but I just got another 20 messages since your last message. So just be patient and know that we're both of us are doing the best that we can.
Well, also remember, you guys, like I talked about this earlier, right? That if the action of government at the inception, at the beginning, is unlawful or unconstitutional, then nothing that they do is constitutional. Which is why, I don't personally take information from individual cases, right? I don't want to know anything more because we are pursuing one very specific action with one very specific issue that will ultimately help all of you, right? Especially in the criminal matter, but also in the family court matter, because if the removal is based upon a breakdown due process, if the arrest is based upon a breakdown due process, I don't need to know anything after that. So all of my attention and all of my energy and all my focus is on the very beginning, right? And that can be the same for all of you. If all of you understand that when you stop defending yourself and you go on offense, but you go on offense in the same position that affects 70 million other people, then we overcome. Right? We reduce the noise of all the other issues and we increase the focus and magnification on the main issue. That's why I don't talk about anything beyond this issue, because if your arrest was unconstitutional, if the removal is unconstitutional, then nothing after it can be constitutional. Nothing. right? And one more thing, my phone doesn't work. So those of you that might have my old phone number, it doesn't work anymore, and I'm not giving out my new phone number. But you guys are welcome to reach out to me by email, but we don't take on individual cases. We don't deal with other issues, because the issue that we are litigating will literally positively affect all of your cases, every one of them.
So Tori, you're in Sevierville. I saw some other people in Sevierville or Sevier County, Tennessee. Tennessee is a hot spot. And I heard Tanawa earlier talking about the law enforcement side and substantive law, and we're not taking on or representing other cases, but I recently filed a 537-page dossier to the Board of Professional Responsibility in Tennessee and the Judicial Conduct Board, and that's what law enforcement should be doing. That was it, getting the information. That was getting the tip of the iceberg information in my case, and then 3 other cases. And I tell people all the time, we've got to start speaking on behalf of others. And so now that I have been the reporting party, and I'm going to release that dossier as an example. Same thing that I did with the notice of liability. That's on the website as well. That's for you guys to go and take and do, and go and gather other people that have the same judge, or other people that have, the same juvenile judge or family court, probate. I think I have some chancery court judges that are in on this too, and you guys all get together and get your information together, and all of you send the notice of liability together to the board. We can't be sitting ducks anymore all by ourselves. So we're bringing all of this together. The judicial oversight dossier, I will release that template. I'm working on volume 2 right now against the other judges. So that'll be fun to release. And then I will release the original dossier so that you can go through and read it, but I've got to redact the children names. So, and then I'll my email, Tori, is Jessica Saxton at...
Jay Saxton. Jay. Just Jay.
It's both, but it's J Saxton at justicewithoutlimits.org.
Give him mine.
And Tanawa's is T Downing at justicewithoutlimits.org. Let's see. Where do you find the link for the Zoom? Link for the Zoom, you can go onto my Facebook. It's a couple videos down, but I will post it tomorrow. I'll pin it to the top. And then the best way to get it is to go to justicewithoutlimits.org and fill out the join the movement form, and then that will get you on my email list. Let's see. Escambia County, Florida. I know.
We've already served there.
Really
We've
bad.
already been there. And guys, what we're doing, it's going to take time, right? I mean, I know that a lot of you, expect that once you inform that they're committing crimes, that they'll stop committing crimes. That's living within a society with a bunch of individuals that are honorable. We find that these people aren't honorable, but we're going to find the honor in the system, and if not, then we're going to prove all of them to be criminals. But regardless, we're doing what's necessary, and we are seeing action, right? We are seeing some people that are coming around. We've got sheriffs that are contacting us. We've got police contacting us. We've got senators and representatives that they're contacting us. We've even got judges contacting us. So people are asking questions, and they're coming to understand what it is that we're saying. But this is a huge animal that we're fighting here, because this is 243 years of flawed misunderstanding of the system of government that we have in place. And so it's going to take a long time to do this. And that's why the more people that are out helping us spread this knowledge and spread this information, like Angela Sutton and stuff, I appreciate them taking the information I have and echoing it. It's just that as they echo it, they need to point back to the source of that information, so that you guys can also, once you know something, then you can actually get the lawful basis behind it, or the lawful basis behind the argument. You guys need that in order to overcome your issues, and that comes from me.
So Thomas, thank you for committing to being at my court hearing on Tuesday. They do not allow any type of recording devices, no phones. They'll check your watches. They'll check your glasses. I mean, it's it's complete lockdown. So you can't bring anything in. That's why I need people there. So bring a notepad and a pen that's not going to run out. Thank you very much. And then I saw another, let's see, there was another question about, Veronica. So Veronica, we can't be everywhere. And I know that everybody wants us to be the one to serve the county, but we have people that are equally as qualified, equally as able to go and serve. So that's why I'm asking people to join the Zoom so that we can connect. And then people in the local counties can go and serve on each other's behalf. So we have the 2-part notice on justicewithoutlimits.org on the docs page, that very first document there. That's the part 1. That's what Tanawa talks about, which is the unlawful arrest and the constitutional supremacy. And then part 2 is where we bring in the Title IV defunding, the unlawful removal of children. So part 1 and part 2. Part 1 is where you provide the public notice and you put that notice on the record. And then part 2 is where you serve the affidavits on someone else's behalf. You can't serve on your own behalf. That wouldn't be a proper service. So you would have to find someone that doesn't have an affidavit, that they don't want an affidavit served. So, but that's what the Zooms are about, is making sure that we can continue to collaborate together, get the people in your local counties together. I mean, we had Melissa and Felicia, they did part 1, part 2, like freaking pros in Iowa, and they served 33 affidavits. 33 affidavits out of one county against multiple judges. That's a lot.
Malia and Carson are also on here. Malia and Carson came together and they did the same thing in Montana.
Yep.
Malia and Carson, awesome.
Well, they didn't do the family part yet.
But
so we just started doing the family part, guys. And so because we had to start raising awareness about the families and the local judges that are just profiting off of destroying the families, and it's just disgusting. If you want to go and see just go listen to some of our services. Get some of the videos from Tanawa's services and just go put it on replay and listen. And then record yourself. Download the scripts, whether it's part 1 or part 2, and record it, reading it like you want it to sound, and then just listen to it over and over and over again. So then that way when you go up there, you're speaking with authority. You're able to look up and look them in the eye and tell them that you're not there to play around. And, you know, we have to remember that we are the authority. We the people are the authority. They're the public servants. And so a lot of this has given a lot of people their voice back, their courage, their ability to get up and stand and speak with the authority that God has given us through our laws. So anyway, do you have anything else?
One more thing.
Yeah.
So
Okay, I'm hopping off. Bye. I'll see you guys all tomorrow on Zoom, 4 o'clock or 4:30. 4:30 Eastern, 3:30 Central, 2:30 Mountain Time, 1:30 Pacific. Love you all. Bye.
all right. So as she was talking, something else came up. So constitutional law, right? It's a body of law as well, kind of like it is statutes, right? So you can actually look up constitutional law, right? And it has subsections as well. Okay, so constitutional law, subsection 171, you guys can look it up. It's also statute, right? It's body of law that governs constitutional law. But constitutional law, subsection 171 says, state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution of the United States of America, right? So that means that state courts are as obligated to guard and enforce every single right secured by the Constitution of the United States of America as the federal court. This is why states are not able to enact their own alternative legislation substituted for the guarantees of the Constitution and go out and enforce it, because state courts are equally obligated to guard and enforce every right secured by the Constitution of the United States of America, okay? So use that in your repertoire of power. Constitutional law, subsection 171. State courts are obligated to guard and enforce every single right secured by the Constitution of the United States of America. When a judge says to you, oh, well, we don't follow the Constitution of the United States of America here, you say, oh, no, you need to go and read Constitutional Law 171, right? Because you are, right? And not only that, but the Constitution of the United States of America also says in Article 6, the judges in every state are bound thereby anything in the Constitution or laws of any states contrary notwithstanding. So the judges of the United States and of the several states are bound to follow the Constitution of the United States of America. So when they say the Constitution doesn't apply to my courtroom, they're full of shit. They don't know what they're talking about. All of you know that they're full of shit and don't know what they're talking about. But we need to back it up with the law. And you know, another thing here is that, remember, right? Like what I'm doing, or what Jessica and I are doing, what I've been doing for years here is, you know, I can't keep a judge from exercising his power. Okay? He's going to exercise power one way or another. But if the power that he exercises is in violation of the law, right, or if he's exceeding the power or authority statutorily conferred upon him, he has just committed a crime. And that's what I do. Again, I do substantive law. I do law enforcement. So I hold people accountable for the crimes they commit. So I can't keep a judge from unlawfully exercising power. But what I can do is I can say, if you exercise power without lawful authority, or if you exceed the power that's statutorily conferred upon you, then you have just committed a crime, and that makes you a criminal. So what I'm doing, what I've been doing for years, is I am drawing a line in the sand, right? And I'm saying to them, this is what the law states. And you guys are clearly operating outside of that. And the definition of a criminal is one who transgresses the law. So the options that they have is either one, return to the established rule of law and obey it, or two, you are transgressing the law and that makes you a criminal, and that's where I come into play. Right? That's where my technical expertise, my professional work and my education comes into play, is I hold criminals accountable for their crimes. I show them that they're criminals, and once they've been deemed a criminal, I don't mess with them anymore, right? I don't return to these city councils or county commissioners, because if I have drawn the line of sand and I've shown them that they're acting unlawfully, I've provided a lawful notice to them, and they choose to continue to operate outside of the law, as of that moment, they are opposing party. They're a criminal. And so I can't go and talk to them again, right? Because that would be witness tampering. So once I provide a notice to them, it's up to them. If they want to be criminals, they can continue down the path that they're on. But once I provide a lawful notice, remember, two things have to happen to mitigate their culpability. One, they must notify the authorities of the crime, the FBI, and if they don't, they haven't mitigated their culpability and they're part of it. Now they're opposing party, and I can't mess with them because now they are actually a defendant against the case that I have, which means that they are now opposing party and I can't mess with them anymore. The second thing is that they must notify their co-conspirators of their intent to no longer participate, but that must be done by an affirmative action. So the way that a city council member or county commissioner would notify their co-conspirators of their intent to no longer participate is saying, I'm no longer going to pay you to commit these crimes, right? Because that would be notifying their co-conspirators of their intent to no longer participate, because if they're responsible for paying people to perform their work, and if in the course of their business what they're doing is unlawful, then if you pay them one more time, then you are now knowingly and willingly paying people to break the law, which means that you are now a part of it, right? So the way that a county commissioner or a state legislator, a senator or representative would notify their co-conspirators of their intent to no longer participate is say, I'm no longer going to pay you to commit these crimes. That would be what they would have to do to mitigate their culpability. For a judge, what a judge would say is, I'm not going to hold this person over unless you, prosecutor, bring me the correct charging instrument, because I'm not going to continue to participate in this criminal conspiracy. The way that a prosecutor would mitigate his culpability is by saying, I'm no longer going to charge by information, Supreme Court of the United States. You can't tell me to break the law because ignorance of the law is no justification for having broken it. I can't obey an unlawful order. So they would have to return to the established rule of law and say, I'm going to make sure that there is an indictment by a grand jury consistent with the Constitution of the United States, and I'm going to follow the procedures that are necessary, which means that I must give the opposing party the opportunity to confront the hearsay accusations against them to benefit from the proceeding that exists for their protection. So that would be the way that these three branches of government would be able to mitigate their culpability in the criminal conspiracy. And if they don't do those things, they remain a part of the conspiracy. And then as they continue to move forward, they are now knowingly and willingly engaging in the criminal behavior. And that's a whole different ballgame. Now you're a criminal. Now it's not negligence. Now it's willful criminal conduct. So again, all that I can do, I can't keep them from exercising their power. But what I can say is that if you exercise power that you don't lawfully have, then what you've done is unlawful, and that makes you a criminal. And according to the Constitution, the judges, this is Article 3, the judges, both of the United States and of the several states, shall maintain their office while in good behavior. All right? Go back and read the Constitution. It says, the judges, both of the United States and of the several states, shall maintain their office while in good behavior. And the definition of good behavior is the avoidance of criminal behavior. So if you do not avoid engaging in criminal behavior, then you are no longer fit to continue in your office, because the Constitution says you can only maintain your office while in good behavior. So if you engage in criminal behavior, that includes perjury, it includes extortion, it includes misconduct, it includes official oppression. If you engage in criminal behavior, you are no longer fit to continue in your office and thereby discharged according to the Constitution of the United States. And that includes any judicial officer of the United States or of the several states. No United States judge can engage in any criminal behavior, right? And if they want to continue in their office. No judge of a state can continue in their office if they engage in criminal behavior. And perjury is, of course, criminal behavior. And that is the effect of an oath. If you don't do what the Constitution of the United States of America requires you to do because you promised to do so under oath or affirmation, you have already implicitly invited punishment in the form of perjury should you fail to fulfill such a promise. If you've already promised to be guilty, if you don't do what you promised to do, then you have already implicitly invited punishment. The burden of proof for a public official is much lower than it is for the people of the United States. For a public official, all we got to do is show the law required you to do it and you didn't do it. And now you've already promised that you would be guilty. You've already implicitly invited punishment should you fail to fulfill your promise, right? So their burden of proof is much lower. All we have to do is show they had a lawful obligation, they didn't do it, and now they've already accepted punishment in the form of perjury should you fail to fulfill such promise. And perjury, every single time, every single instance of the crime is punishable by 5 years in prison, and you can never hold public office again because it's a violation of public trust, meaning you can't be trusted by the public to do what you promised. So all these public officials that are failing to mitigate their culpability in the criminal conspiracy once notified, right? Tens of thousands of these people we've notified, right? These attorney generals and assistant AGs that I've notified, these judges that I've notified, these county officials, these city officials, all of these people that I've notified that have chosen to continue to allow this to continue has already implicitly invited punishment in the form of perjury for failing to fulfill the promise they made. They have not mitigated their culpability and thus can all be held accountable. So we want them to step up, right? This is going to be the least destructive approach to this. I know that if we can't get government to step up, or certain people within government to step up and do the right thing and obey the law, that this is going to be much more messy than it needs to be. And the people of the United States don't deserve to have this be messy, because this wasn't the people of the United States' fault. This was government's fault. Government exceeded the power authority statutorily conferred upon them. They failed to obey the limitations of power that the people delegated to them, right? So this isn't the people's fault, the situation that we're in. This is government's fault. And government has to take action to fix it. And if we can't get them to do that, then this is going to be much messier than it needs to be. And I don't want it to go down that path. I don't want to have to go down that path. That's why I keep saying that in these services is I don't want to have to convert these affidavits into complaints, because I don't want to have to head down that path. I'm hoping and I'm praying that we're going to start getting public officials behind this, supporting this. And when we do, we're going to see a massive number of them step across either a fear of the punishment and penalty that comes with failing to obey the supreme law of land, or out of just simple honor, right? And acceptance of that honor, and realizing that you yourselves, government, are what's destroying America and destroying your own institution. Absent honor, this institution doesn't work anymore. Absent honor, these judges have no power anymore, because absent honor, they become dishonored, right? And dishonor is not the realm that judges are able to operate within. People in the United States don't accept that, and we never will, right? So, So yeah, I would agree with the sheriffs, but we've only got one sheriff. I think we've got two sheriffs, but they're not publicly helping. So we've got a couple governors that support this privately but not publicly. We've got some representatives, both state and federal, that support this privately and not publicly. We've got a couple sheriffs that support it privately and not publicly. The problem is that in order to successfully move ahead, in order to get to the next level, we've got to get these people that support it to come out publicly and support it and say, oh yeah, the Constitution says it, we have to do it, we're going to enforce it against those that are violating it. We have to reach that point, and that means that we've got to find a public official that has enough power that will openly and publicly come out in support of this, and that's what we have to have. So we're waiting to find that person. We hope that we'll find them soon, but we're still looking. But I hope to find them soon. All right, guys. So I'm gonna go. I thank you guys so much for everything. Again, we operate on donation only. We have to do it that way for very specific reasons, but that is one of the large limitations of our ability to be able to go places, to be able to do things, is because we don't have, unlimited resources. We don't have any sort of corporate backers or whatever. So we operate on donation only. If you guys want to donate, please don't get scammed. All right. There's lots of people that are pretending to be me and Jessica that reaching out to you. Just understand, I never reach out to anybody. Jessica never reaches out to anybody asking you for money. We have never done that, and we never will. The only time we do it is like this. I will say, if you guys want to donate, you're welcome to donate, but I will never send you a message saying, please give me money. All right. That will not happen. But if you do want to donate, we have Cash App, we have Chime, we have Venmo, we have PayPal. They are all exactly the same as We Shall Be Free. All right, this is the We Shall Be Free TER. Therefore, the way that you would donate would be We Shall Be Free. If someone asks you to donate to any other source, it's not us, right? It's a scammer that's going to steal your money. If someone says to you, please get an Apple gift card or Apple Cash card and send me the number, that's not me or Jessica. That is a scammer, and they're going to steal from you, okay? So please don't get scammed, and please don't blame me if you guys do get scammed. There's a lot of people that have been scammed, and I'm sorry that's happened, but I can't control their actions. All I can say to you is please be smart with your money, and if you want to donate to us, the only way that you can do it is We Shall Be Free, all right?
Or Justice Without Limits.
Justice Without Limits doesn't exist. They shut it down.
My Venmo.
Oh, Venmo.
And then some people only have Zelle, but all of our...
I don't want to confuse anything.
Yeah, but the only way that you can donate, if you're wondering, is go to the website under the operations tab and then click on the donate, and it'll have all of our, that's it. What comes to us is just those. I think there's 6 like QR codes that you can choose from.
And that's also one of the reasons why we went with the email as well, justwithoutlimits.org email, is because they've been copying our email with Gmail, and so at least now they can't have an email that says justwithoutlimits.org, right? Because we control that domain. So, if someone sends a message out, an email out from TanawaDowning3579@gmail.com, that's not my email. But people aren't recognizing that. They're seeing, oh, well, this is Tanawa and he's asking for money, so let's send him $2,000. And that's happened many, many times. Like, these people have stolen tens of thousands of dollars from all of you. Money we don't have. Like, we don't get that kind of donations. We're getting $20 here and there, and I appreciate that. It certainly keeps us going. But these people have stolen a lot of money from you guys, and it sucks. But anyway, if you guys want to donate, you can. Again, the website provides it. If you want to donate directly, We Shall Be Free, Cash App, Chime, Venmo, PayPal. There are a couple other options, including Zelle, that's on the website. You go to the website. But my point here is that if anybody asks you for money, it's not us, all right? We will never message you asking for money. And we will never offer to come to your city and support you on your case, because once again, what I'm arguing and litigating will ultimately destroy and render void all of your actions or judgments. If you have a charge against you, or if you have a conviction against you, what I'm litigating at the beginning is going to render that void. So I don't need to worry about that, right? If they're prosecuting right now in a case, it would be a distraction for me to come and try to help you with your case, because ultimately the issue is they didn't have authority to make the arrest. And if they didn't, then what they're doing to you is not valid. It's void ab initio. So this issue will ultimately resolve all of your problems, right? And I don't have to worry about all of those. I'm going back to the beginning. We're going to challenge it. We're going to address it, right? Now, civil, you asked about civil. I don't do civil. That's an attorney. You're going to have to get an attorney in. But before you can get an attorney, I got to win the beginning. Because today we are under the belief that states can do it because no one's argued this, right? No one's brought this to the Supreme Court and gotten the ruling consistent with the law, right? No one's done that yet. So before, and attorneys don't think about this because attorneys actually do the second part. So an attorney is trying to do a civil rights case, and they're going to say, well, yeah, the state can be your accuser, right? Because the Supreme Court said so or whatever, because that's the way it's been done for 200 years. They don't think outside the box to be able to come in and say, okay, well, this is the issue. We want to deal with the root issue, right? So the civil matter has to happen after I deal with this. Before you can have a right to seek relief on, right, or remedy on, we must first establish the right. Okay, the right is that the state does not have the power to be both accuser and judge in the same cause. That right to not be prosecuted by a state doesn't exist yet. Even though it's in law, it doesn't exist yet because no one's litigated this yet. That's what I'm doing. So once I finish litigating this, then you'll be able to go to your civil, through a civil case and seek relief and remedy and whatever else you want. But you would need an attorney to do that. I'm dealing with the law and the enforcement of the law because that's what my technical expertise is. I deal with law enforcement. I don't deal with that. But before an attorney can step in and do anything, we first must establish the right, and the right derives from the enforcement of the law, right? The law says this, and it's not being enforced because no one's ever challenged it. No one's ever brought that up because everybody believes that the right does not exist because the government is not fulfilling the obligation that the law created, okay? So yes, there will be a whole bunch of civil matters that all of you will be able to do. You'll be able to seek, relief and remedy for all of these injustices that government's committed against you. But before you'll be able to do that, I got to first win this first part, which is why the more you guys come across and help me, push the issue, the law. This is what the law states. You guys are breaking the law. And when we prove that government has broken the law, then everything government has done is unlawful. And that's where you'll obtain your civil relief and remedy, right? But that's not what I do, right? I do the first part. I establish the law, enforce the law, and through law enforcement, then we can seek your relief, okay? Hope that helped. All right, guys. So thank you so much for everything. I will read through this as we can here and respond. Thank you guys so much for spending so many hours here with me. I hope you guys had a wonderful Thanksgiving and can't wait to see you guys out there in the field. We've got a pretty busy week this week. We don't have a whole lot of services, but we have a whole lot going on. Hoping, praying that some of them will pan out. So I don't think we're telling where we're going to be, but I do know that I believe on Saturday we're going to be in West Virginia, Charleston, West Virginia. There's a Senate event for the, huh? On Sunday. Okay, so on Sunday we're in West Virginia in Charleston there, and we're going to be at that Senate event there. So if you guys are in West Virginia area, you want to come out and see us, we'll be there. We're going to be crisscross, 3 to 5. I don't remember which senators are doing it, but we'll be there for that. And again, last week we had an awesome service to the state of Delaware where we served a joint session of both the Senate and the House. That video is available on both TikTok and Facebook. If you guys want to recall any of this, you can go to my YouTube. The phone just died, so this last few minutes, they're not recording. But you can go to YouTube, and this video will be available there for you. Over on Facebook, it'll be available for the next 30 days. So you guys go back and listen to this again if you want. But we're going to be crisscrossing a number of states. I think we're going all the way from where we're at right now in the Northeast, all the way to Michigan, and then Michigan down to West Virginia, and then ultimately back down to Tennessee for early next week for Jessica's stuff in Tennessee. So thank you guys so much. And again, look forward to seeing you out there in the field. And God bless y'all. All right, have a great night. Thank you. Thank you, Facebook. Appreciate it so much. We have been to Philadelphia. We serve the city of Philadelphia. That video is available on Facebook here. You can do a search on my page for Philadelphia and it should pop up. It's also on my TikTok as well as also YouTube. So we have served Philadelphia. In Pennsylvania, we've served one of the House members of the Senate Judicial Oversight Committee. We did that week before last in Harrisburg. We've served Philadelphia. We've served Pittsburgh. We've served Allentown. We've served what is that place where Bam Margera lives? He lives in anyway, we served that county, and then we served another county, a county somewhere around Allentown. I don't remember, but whatever that county is that Bam Chester, yeah, he lives in Westchester. Yeah, so we served Chester County. All of those are available. We've served your Attorney General and we've served your Supreme Court as well. So
we're looking for people in Monroe County, Pennsylvania.
Monroe County, Pennsylvania.
Yeah, they're going to serve very soon. There's a whole group down there that's going to go tear it up.
Okay, Monroe County. Pennsylvania is pretty well covered, although Pennsylvania is one of the main battleground states because it's one of the states that removed the grand jury from the Constitution back in the mid 80s. So the state of Pennsylvania does not conduct a grand jury at all. They removed it. That is facially unconstitutional. So Pennsylvania is absolutely, one of the battleground states, along with Washington, Connecticut, Michigan, North Dakota, and so on. So Pennsylvania, we're going to get you covered. But you've been pretty well covered. We will probably have to return and do another service to the state legislature because I wasn't really pleased with the service that we did. But we have served actually the chief of staff for one of the members of the House Judicial Oversight Committee. All right. All right, guys. We'll talk to you here soon. Thank you guys so much. Well, okay. So we'll run through this one more time here. The only states that we have not served the Attorney General and the Supreme Court is West Virginia, Hawaii, and Alaska. Every other state, we've served both the Attorney General and the Supreme Court. Okay, both, right? Both of them. We have video, we have witnesses, we have the certificate of service. We have all of those for the 47 states. We have not done West Virginia yet, or Hawaii, or Alaska, right? We will get West Virginia done, right? We will serve the AG and the Supreme Court there, but we may or may not be able to make it to Alaska, Hawaii. We don't have the money to do that unless we get specific donors that will be able to support that specifically. Then we will not be able to make it to Alaska, Hawaii, right? To serve the AG and the Supreme Court. That doesn't mean that they won't have to be held accountable and do this. It just means that we won't, we're very limited in our funding.
Guys, God is going to provide us that somehow. I am trusting that, and I think we're going to get all 50 states. So don't give up.
Okay. Now, as far as the serving of the legislatures, okay, remember when we first started serving the city councils and county commissioners, I said that I was going to do 55 of them. All right, 55. To date, we've done, I believe, 59. Right, so we've exceeded the 55. Right, with the original intent, we exceeded what I originally planned, the 55, and we've actually served 59. But that doesn't mean we're stopping. Jess still wants to get as many counties done as possible. And I agree. We're going to continue to do this and bring the attention, as much attention as we have to bring until the Supreme Court finally stops ignoring this and agrees to hear the case, right? We're going to continue to do that. But I'm focusing now on the state legislatures. We have to get into state legislatures because they're the ones that pay the judges. We got to provide them notice. The 55 counties and cities was practice to get ready to get into the state legislatures and start serving them because I had to practice and get myself ready and everything else. And that's where we're at. The only state legislatures that we've done so far is Georgia and Delaware. Okay. Pennsylvania, we went to the judicial meeting, but they didn't let us speak, right? So I had to go and I had to serve one of the judicial oversight members, and we only served through his chief of staff, which is certainly his agent, and I would agree that it was served, but we didn't speak, right? And so that's why I say that we'll probably have to return to Pennsylvania and actually speak But the problem is getting in is really difficult. Typically, a lot of them don't have hearings. When they do have hearings, you have to speak specifically on their agenda item. We have to find the right committee because you can't do it in a session. You can only speak at a session by invitation only. And lots of times, even at the committees, you can only speak at one of them only. But the point is that as of right now, we want to serve both sides of the house, because remember, every single state in the country has two houses, except for Nebraska. Nebraska only has a Senate. They don't have a House. But every other state has both a House of Representatives and a Senate. And so we have to serve both sides, right? I would accept that one would be sufficient to speak at, but we have to provide the notice into the clerk of the House or the clerk of the Senate, which is the representative or the agent of those. So we actually have to get to both. But we've only served just those two states so far, Georgia and Delaware. But we're gonna do all of them again. It's gonna take some time because there's a lot that aren't in session until January anyway. So we got another month where we're really not able to do a whole lot with the state level. And then as far as the cities and counties are concerned, my focus has been on the bigger ones. We want to get to the biggest and serve the biggest because that's the greatest bang for a buck. Jess has been looking at, smaller counties because the smaller counties seem to have more corrupt judges, but we don't get the greater bang for the buck. When we go to a county that only has, 50,000 people, we're not advocating for the massive number. Like when we go to LA and we're advocating for 10 million. We want to do as many as possible, but my focus has been greatest bang for a buck because that's going to be what's going to be necessary to get heard by the court. Jessica's been focusing on where are the hottest places with the most corrupt judges. And I think that we're going to have to find some sort of, meeting between the two. But nonetheless, everyone needs to be advocated for. I get that. But, my concern is how quickly can we get to the court and get heard by the court? And that's going to require the greatest number of people that we serve for, right? Nebraska, I've already done Nebraska. So Nebraska, we did Lancaster County, which is Lincoln, Nebraska. That's the capital. And we served the AG and the Supreme Court.
But the counties still need to be served.
Yeah. The only county that we've served in Nebraska is Lancaster County. But we tried to get into Omaha a couple times and Omaha it hasn't worked out thus far. But there's a lot of times that we go into places and then we get screwed. Like just the other day we were in Baltimore County and they wouldn't let us speak at their work session. So we're gonna have to return to Baltimore County. But we were just in Baltimore County just the other day and they wouldn't let us speak. So we're gonna have to hit them again. But as far as the states are concerned, all of you ask about these states. We've served the AG and the Supreme Court in 47 states. And then if you want to see the list of states that I've served, you can go to my Facebook page on the post that's pinned. And that's actually the Lancaster County service that I did. And if you scroll into the writing of it, right, it actually lists every single city and county that we've served. So if you want to know the cities and counties, you can actually go to that pinned post there, and it'll tell you. You just scroll into it, and it tells you all the cities. I believe we've served 38 cities and another 28 counties or something like that. This is what Jessica and I personally serve. So that list is exclusive to what we have done, right? It's not exclusive to what everybody's done. So she says she's working on that. All right, she's working on that. All right. Thank you guys so much for everything. Appreciate it. Please continue to like, follow, share. Please keep donating. We need the support. The VA is taking a little bit longer. I've submitted the notice of intent to the VA for the disability, but we're still waiting on the FOIA request to give me my medical records so that I can give what's necessary to support. So it's going to be at least another month before I'll see funding coming from the Veterans Administration for my sustained injuries. But again, like my hope is that the VA will approve me for for disability that will be backdated back to 2004 when I separated, and that will be enough in capital money to be able to get into an RV so we can more comfortably do the work that we're doing. But please continue to donate because we do still need it. All right. Thank you guys so much. Appreciate everything. Love you. And again, happy Thanksgiving. And hope you guys had a good one with your family. God bless, guys.